Yes.
Your Lordship, the transfer petition has been filed by the petitioner while seeking transfer of the divorce proceeding pending before the Court of Family, Principal Judge, Family Court number 3 to Nalbari Court, Your Lordship. Since there
Madam,
is
you see
another
what
case-
is the distance between Nalbari and Guwahati?
Your Lordship, since there is another case pending in Nalbari, Your Lordship. There's another maintenance cases pending there, Your Lordship.
Heard Ms. Chaudhary, learned counsel for the applicant. This application under section 24 of the Code of Civil Procedure is preferred by the applicant for
Another case pending in Nalbari, Your Lordship. The matter may be stayed until the disposal of the transfer petition, Your Honor, before the Principal Judge, Family Court number 3.
learned counsel for the applicant submits that. This application under section 24 of the Code of Civil Procedure is prepared by the applicant for transferring FC Civil Case Number 174 of 2026 pending before the Court of Learned Principal Judge, Family Court number 3, Kamrup M. Guwahati, to the Court of Learned Principal Judge, Family Court Nalbari. The learned counsel for the applicant submits that another proceeding being, what is the number of that proceeding?
Your Lordship, that is FC Criminal Case number 41/2026. Your Honor.
FC Criminal Case Number 43 of 2020.
41.
FC Civil Criminal Case Number
41 of 2026, Your Lordship.
41 of 2026 between the same parties
Yes.
is pending before the Court of Learned Principals as Family Court at Nalbari.
Yes.
And as such, the FC Civil Case Number 174 of 2026, which is pending before the Court of Learned Principals as Family Court number 3, Kamrup M. Guwahati, may be transferred to the Learned Principals as Family Court Nalbari. The submission of learned counsel for the applicant needs further consideration at this stage. Let notice be issued to the respondent returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. List the matter after 4 weeks. Till returnable date, further proceeding of FC Civil Case Number 174 of 2026. Pending before the Court of Learned Principal Judge, Family Court number 3, Kamrup M. Guwahati, State. List after 4 weeks.
Your Lordship, this is also the transfer petition filed by the petitioner wife seeking transfer of the case to Golpara, Your Lordship.
Or Ms. Chaudhary, learned counsel for the applicant. This application under section 24 of the Code of Civil Procedure is prepared by the applicant for transferring of FC Civil Case Number 655 of 2023 pending before the Court of Learned Principal as Family Court number 1, Kamrup M. at Guwahati, to the Court of Learned District Judge at Golpara, where the petitioner is residing presently.
Please residing in Golpara, Your Lordship.
Golpara.
Yes, Your Lordship.
The learned counsel for the applicant submits that the applicant herein is residing at Golpara, and the proceeding is initiated by the opposite party herein before the Learned Principal Judge, Family Court number 1, Kamrup M. Guwahati. And as such, there is a requirement of transferring the FC Civil Case Number 655 of 2023 pending before the Court of Learned Principal Judge, Family Court number 1, Kamrup M. Guwahati, to the Court of Learned District Judge at Golpara. The submission of learned counsel for the applicant needs further consideration at this stage. Let notice be issued to the respondent returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. list of performance, till returnable date. Further proceeding of FC civil case number 655 of 2023 stands state. List of performance.
Matter may be stayed till the disposal of the case. Matter may be stayed in Principal Judge Family Court till the disposal of this present petition, Your Lordship.
Item 3.
No page, Lordship. The
Yes.
petitioner is living now, Lordship, is Borkata, and she has one child, and she is very poor. She is dependent on the only maintenance. No? Earlier, she was living with her brother in Gauhati, Lordship. Her brother was a auto rickshaw driver. Now he has shifted to Borkata, his native village, due to some problem. She also shifted to Borkata, and the son is also admitted in-
Where the petitioner is living?
petitioner is living in Gauhati. Lordship. He is a bank retired person. Bank retired. He has a good financial. He can go to the Borkata. Lordship. The two cases are pending in
Petitioner is a retired person.
retired
He is residing at Gauhati,
Gauhati. Lordship.
and the proceedings are initiated at Borpeta.
No, Kamrup, Lordship. Now the prayer is to transfer the two cases, Lordship. One is guardianship, another FC civil, Lordship. These two cases may be transferred to the Borkata, Lordship, because she is suffering from financial hardship and she has some problems coming to Gauhati, Lordship, with her son. Please repeat, it's 8,000
No,
per month. But let's say that is also very irregular. He is paying irregularly. That's it. FC civil case number 437 and Miss G case number 2023, Lordship.
this FC criminal case number 132 of 2023 is pending in which court?
Guwahati, Lordship. Kamrup.
Guwahati.
Kamrup. All three cases are Kamrup family court, Lordship. Kamrup.
So now these proceedings are to be transferred to the court of
Borpeta family court.
Borpeta.
Borpeta.
Heard, Mister, your name,
G.
please.
Sharma. G. Sharma.
Learned counsel for the applicant. This application under section 24(1), which in bracket small a of the Code of Civil Procedure, is preferred by the applicant for transferring FC civil case number 437 of 2023, comma, Miss, within bracket Z case number 23 of 2023, and FC criminal case number 132 of 2023. Pending before the Court of Learned Principal Judge Family Court, Kamrup M and Gauhati, to the Court of Learned Principal Judge Family Court, Borpeta. The learned counsel for the applicant submits that the applicant is Ranju Pathak.
Ranju Pathak.
She is presently residing at Borpeta.
Borpeta, Lordship.
That the applicant herein is residing at Borpeta, and the proceeding of FC civil case number so and so, this guardianship case number so and FC criminal case number so and so are instituted before the Court of Learned Principal Judge Family Court at Gauhati by the respondent herein. 10. It is difficult on the part of the applicant to contest the aforementioned proceeding at Gauhati since she has been residing at Barpeta. And under such circumstances, there is a requirement of transferring the aforementioned cases from the Court of Learned Principal Judge Family Court at Gauhati, Kamrup M. Gauhati, to the Court of Learned Principal Judge Family Court at Barpeta. The submission of learned counsel for the applicant needs further consideration. That this is this notice be issued to the respondents, returnable in 4 weeks, step be taken by speed post and also by usual process within a week from today. So do we stay the proceeding?
Yes, sir.
The learned counsel for the applicant submits that till disposal of this transfer petition, there is a requirement of staying further proceeding of the aforementioned proceeding before the Court of Learned Principal Judge Family Court at Gauhati. Accordingly, taking note of the submission of learned counsel for the applicant, further proceeding of FC civil case number so and so, Miss guardianship case number so and so, and FC criminal case number so and so stands state till returnable date, list after 4 weeks.
Not so good.
Item 4.
May it please your lordship, this is a petition under section 24 of Code of Civil Procedures seeking transfer of restitution of conjugal rights proceeding from the family court at Barpeta to the component family court in Sunitpur. The petitioner is the wife. She has been residing at her parental home in Sunitpur since December 2020, along with a minor child. So it's a settled principle that the matrimonial dispute, the convenience of the wife ordinarily deserve greater consideration, particularly where she is residing with a minor child and has no independent income. She has been working as a household for supporting the child, and her family, father and mother, both are very poor to support her. So from going from Tejpur to Barpeta,
Heard, Mr. Your name, please.
M. Islam.
Learned counsel for the applicant. This application under section 24 of the Code of Civil Procedure is preferred by the applicant for transferring of TS within bracket MFC suit number 107 of 2026 pending before the Court of Learned Principal Judge Family Court at Barpeta to the Court of Learned Principal Judge Family Court, to the Court of Learned District Judge at Sonitpur at Tajpur.
In the meantime, your lordship may kindly stay further proceedings before the learned
The
family
learned
court
counsel
Barpeta.
for the applicant submits that the applicant is the respondent in title suit within bracket MFC number 107 of 2026. And the said suit was instituted by the respondent herein at Barpeta. But the petitioner herein, but the applicant herein, along with her minor son or daughter, daughter is residing at her parental abode at Tezpur. And her financial condition is not good, and on such count, it is not possible on her part to contest the aforementioned proceeding at Barpeta. And as such, there is a requirement of transferring the aforementioned proceeding from the Court of Learned Principal Judge Family Court Barpeta to the Court of Learned District Judge at Tezpur, Sonitpur at Tezpur. The submission of learned counsel for the applicant needs further consideration. At this stage, notice be issued to the respondent, returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. list after 4 weeks. And considering the submission of learned counsel for the applicant, and also considering the facts and circumstances on the record, further proceeding of title and FC suit number 107 of 2026 pending before the Court of Learned Principal Judge Family Court. Stands state Family Court, Barbeta stands state till returnable date, list after 4 weeks.
Obliged.
Item 5. Item number 5.
None appears for the petitioner on call, lays the matter after a week. In the event of subsequent non-representation, appropriate order shall follow.
Item number 6.
May it please your lordship, in this matter, your lordship, the respondent filed a title suit for specific purpose of contract, your lordship, and in that case, the dependent filed a written statement, your lordship, stating therein, your lordship may kindly see page 25 onwards, that is a written statement copy. Your lordship may kindly see page 26. The actual facts of the case was that the defendant and the plaintiff are well acquainted to each other from many years ago. That in the year 2019, defendant suffering in serious illness, and immediately she admitted to ACMH at Tezpur. Later on, she was admitted in Mission Hospital, Tezpur, after examination. The defendant came to know that she was suffering in appendix problem. Later on, she also admitted in SK Nursing Home at Tezpur town, and again she was admitted in Ananta Memorial Hospital and Research Center, Mahatali, Tezpur, during that 2 years of the year 2017 and 18. That after done the operation, the defendant badly infected, and she also admitted at Naim Hospital, Shillong, but she did not cure from the infection. Thereafter, again, she admitted in the Assam Medical College Hospital at Dibrugarh. Later on, the defendant also taking treatment at Numan Das Nursing Home, not Lakhimpur, but the defendant did not fully recover. So, your lordship, thereafter, she has to approach the husband of the respondent for a certain amount of loan, as she is suffering from heavy financial burden. So she obtained a loan to the total amount of 4,50,000 initially. So that was at the interest of 7%, which amounts to 5,20,000. So the thing is that, your lordship, while taking that loan amount, the other side, your lordship, the respondent, they have obtained certain documents, including 20 rupees stamp papers and a landed property. So in view of that, she put her signature knowing it to be a loan agreement, not the sale agreement actually. So what happened? According to your lordship, this written statement was filed. Surprisingly, your lordship, a compromise petition, your lordship may kindly see para 3. May I take your lordship to para 3? Para 3, page 3, your lordship. That during the proceeding of the said suit, the engaged counsel for the petitioner's daughter-in-law asked her to come to the court on 5/4/24 and told her that the respondent wanted to compromise the matter and asked her to sign some documents. The advocate for the petitioner's daughter-in-law was Someshwar Bora, and he did not explain as to what was actually written in the said petition. The petitioner's daughter-in-law, who was the defendant in the said title suit, was made to believe that the compromise has been done so that the respondent returns the original sale deed, and to enable the petitioner's daughter-in-law to obtain loan from bank and return the loan amount to the respondent with interest. However, the petitioner and his daughter-in-law were surprised on coming to know that an execution case has been filed against her by the respondent. The petitioner and his daughter-in-law thereafter engaged new sets of counsel, and then only they could discover that on 5/4/24, the petitioner's daughter-in-law was asked to sign a compromise petition filed under Order 23 Rule 3 of the CPC, and as per the said compromise petition, petitioner's daughter-in-law will return an amount of rupees 15 lakhs within 8 months, and if she does not refund, then she will have to accept rupees 5,40,000 and execute the sale deed of the suit land. It is pertinent to mention that as per the averments made in the plaint, this suit property was to be sold for a price of 13 lakhs, and the respondent has paid a total amount of rupees 7,60,000. The petitioner's daughter-in-law does not know much the English language, and she did not know as to what was written in the compromise petition. there is no way that a person after receiving only rupees 7,60,000 will agree to return an amount to rupees 15 lakhs by way of misrepresentation, fraud. The signature of the petitioner's daughter-in-law was obtained in the compromise petition filed under Order 23, Rule 3 of the CPC. On the same day, that is 5/4/24, the suit was decreed on compromise, and thereafter the decree was prepared.
No, you say,
Thereafter,
you
yes.
have filed a joint application there.
Your Lordship, what happened, Your Lordship? Based on that, Your Lordship, that impugn order was passed on 5 on the same day. What happened, Your Lordship? That while the title execution was in process, Your Lordship, the petitioner
Now,
filed.
whether the question is, can you adduce evidence during the execution proceeding?
It's still pending, Your Lordship.
Hmm?
The thing is like this, Your Lordship.
Why don't you challenge the compromise decree then?
No, she's challenged, Your Lordship. She filed a petition under section 47. Your Lordship may kindly see page
No,
56.
whether the trial court can deal with the same under section 47.
The trial court didn't listen to her contentions made in that,
Okay,
Your
let
Lordship.
notice go at this is this.
Your Lordship,
Heard
if-
Mr. Sharma, learned counsel. for
Your
the
Lordship, pending disposal, Your Lordship, that impugn that order may be, that impugn proceeding, Your Lordship, that may be stayed, Your Lordship.
No, this execution proceeding,
Now, even in execution proceeding, Your Lordship, I filed a petition, Your Lordship, under Order 21, Rule 99-101, read with section 47. That was not considered. Your Lordship may kindly see, Your Lordship may kindly see page 63. That was my petition, 63, Your Lordship.
no, you can challenge the decree, that compromise decree.
The matter is in execution process, Your Lordship. So I
Maybe-
filed this petition, Your Lordship, because Your Lordship may kindly read that section, Your Lordship. What
No,
the-
no,
what-
no, no, no. Let notice go at this is this. When the execution proceeding was initiated,
The execution proceeding, Your Lordship, that was,
25,
yes. That is what I should, the title execution case number 3 of 25.
heard Mr. Sharma, learned counsel for the petitioner. This petition under Article 227 of the Constitution of India is directed against the order dated 6/1/2026 passed by the Lord Civil Judge Senior Division Sonitpur in title execution case number 3 of 2025. It is to be noted here that by impugn order dated 6/1/2026, the learned civil judge senior division Sonitpur in title execution case number 3 of 2025 has dismissed the petition.
So my prayer is very simple, Your Lordship. This matter may be remanded back to the concerned trial court, Your Lordship, to hear my petition, Your Lordship.
Under section 47 CPC. Dismiss the petition number 642 of 2025 dated 10/9/2025 seeking permission to adduce oral and documentary evidence. And also the petition number 472 of 2025 and 553 of 2025. Peruse the petition and the documents placed on record and also peruse the impugn order dated 6/1/2026. Let notice be issued to the respondent returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. List after 4 weeks. Though the learned counsel for the petitioner has submitted that the impugn order may be set aside and the matter may be remanded to the learned trial court to dispose of the petition under section 47 CPC. Yet,
Order 21, Rule 99 and 101, your lordship. It was the petition, page 63, I next a copy.
In the given facts and circumstances of the case, this court is of the view that hearing of the other side is necessary before remanding the matter to the learned trial court, the executing court. And accordingly, the submission of learned counsel for the petitioner stands repudiated. List the matter after 4 weeks.
Item number 7.
Yeah, please. My lord, in this case, my lord, we are agreed by order, my lord, that is at page 136, annexure 8, my lord. As by this order, my lord, impugn order, my lord, the learned civil judge junior division, my lord, allowed the petition for amendment, my lord. After the trial has commenced, the evidence was filed. They did not appear for cross-examination. They thereafter they filed the amendment petition, my lord. So, my lord, there is judgment, my lord, because after commencement of trial, amendment is generally not allowed, my lord. But without taking into consideration those things, my lord, the trial court, my lord, allowed the amendment petition. Initially, a suit was filed for partition, my lord. We filed counterclaim, and thereafter they filed their WS. After filing of the WS, they filed their evidence, written evidence on affidavit or the witness. But they did not appear for cross-examination and changed their advocate. And after changing their advocate, the new advocate filed this amendment petition. So, my lord, I'll lawyer your attention to page
The
136.
case was pending for cross-examination of the witnesses.
Cross-examination of the plaintiff witnesses.
Whether any cross-examination was done.
No, cross-examination could not be because they did not appear. They did not appear, they keep on taking time. They keep on taking time and change their advocate and file this amendment petition. And my lord, by amendment petition also, they want to, my lord, change the jurisdiction of the court also. Initially, they filed the case, the suit value was only 1,000. Later, they want to enhance it to 15 lakhs. So the jurisdiction will also change, my lord. And we have also filed counterclaim, and in which we have quoted the same court fee, my lord. So if the same is sent to, my lord, the civil, the senior division, my lord, then again there we have certain complications, my lord. Page 136 to 141. Main question involved is whether after commencement of trial, this amendment can be allowed.
Amendment for it as a order. And copy this. Where is that application? File for amendment?
I'm coming. My lord, that is at page number 118, Annex 6.
118.
It is the matter translated. Uh, Vernacular starts from my lord, page 126.
Page number 100.
My lord, vernacular 126. My lord, in the translated 118. 118, my lord, 118. Annex 6.
So whether they have assigned any reason as to why they could not file the application before commencement of the trial?
My lord, in para number 3, my lord, they have stated that for proper execution of the plaintiff's claim in the suit, it was absolutely essential to mention certain necessary facts and details of the documents. However, the plaintiff's previously engaged counsel did not inform the plaintiff about this matter at all. Later, when the plaintiff engaged the currently appointed advocate to conduct the case responsible, given the petitioner understood the necessary of including those facts in the petition, and therefore it is highly necessary amend the petition by including those facts. So mainly it was change of advocate. And we have also stated that the petitioner, my lord, the plaintiff, presently respondent, is a retired government employee, my lord.
And where is your objection petition?
My lord, it starts from page number 132 to 135. In para 9, my lord, in page number 130, we have mentioned, my lord. We avoided cross-examination, my lord. And my lord, petitioner also filed his evidence that your lordship will find that page number 79 onwards.
So when the evidence in affidavit was filed?
I'm just checking, my lord. Plaintiff witness 23 4/5/23. Oh, no, my lord. I'm sorry, my lord. It's not 4/5/23. Sorry. 3124, my lord. Page number 83, my lord.
And when the application for amendment was filed,
Application for amendment. 29/11/24.
29/11.
24. And my lord, the main plaintiff, my lord, he filed it on 4/12/23.
Hmm?
Other witness filed in the year 2024, but the main witness, PW1, my lord,
Hmm.
he filed on 4/12/23. That is at page number 111, my lord. Nearly after 1 year, my lord, this petition has been preferred.
Heard Mr. Aishwarya, learned counsel for the learned counsel for the petition of this petition under Article 227 of the Constitution of India is deferred by the petitioner. Challenging the order dated 23rd/4/2026 passed by the learned civil judge junior division number 2 Nalbari in Mijje case number 169 of 2024 in connection with TS case number 118 of 2022. It is to be noted here that by the impugn order dated so and so, the learned civil judge junior division number 2 Nalbari, within bracket, trial court hereinafter, has allowed the petition number 1596 of 2024 filed by the respondent herein under order 6 rule 17 read with section 151 CPC for amendment of the plaint. The learned counsel for the petitioner submits that the petitioner is the respondent in title suit number 118 of 2022 pending before the Court of Learned Trial Court. And in the said petition, in the said title suit, the petitioner herein as a respondent file written statement and thereafter issues have been framed, and the respondent herein have filed their evidence on affidavit on 4/12/2023 and 3/1/2024. And thereafter, the case was fixed for cross-examination of the witnesses. And on 29/11/2024, the respondent herein had filed one petition, being petition number 1596 of 2024 under order 6 rule 17 read with section 151 CPC for amendment of the plaint on the ground that at the time of typing of the plaint, some mistake made in the plaint, and the respondent herein were not aware of the same. And thereafter they have changed their counsel, and They filed a filed a petition on 29/11/2024 for amendment of the plan. And the learned trial court, without considering the provision of Order 6, Rule 17, without considering the proviso to Order 6, Rule 17 of the Code of Civil Procedure, has allowed the same. Referring to a decision of Honorable Supreme Court in the case of Vidya by and others versus Padmai Atha and another, reported in 2009 to SCC, page number 409, submits that only fulfillment of the condition laid down in the proviso to Order 6, Rule 17, CPC, the amendment can be allowed. And in the instant case, the respondent hearing in their application has failed to assign, failed to demonstrate due diligence on their part as to why, before commencement of the trial, they could not file the application for amendment. And on such count, the impugned order dated 23rd/4/2026 fails to withstand the legal scrutiny, and therefore he is contented to set aside the same. But having heard the submission of learned counsel for the petitioner, this court has carefully gone through the petition and the documents placed on record, and also perused the impugned order dated 23rd/4/2026. And this court finds substance in the submission of learned counsel for the petitioner. It appears that the application for amendment was filed on 29/11/2024, whereas the respondents herein had filed their evidence in affidavit on 4/12/2023 and 3/1/2024. And in the said application, they have failed to demonstrate their due diligence as to why the application could not be filed before commencement of the trial. In the case of Vidya Bhai and another Supreme Honorable Supreme Court, in paragraph number 10, held that by reason of the Civil Procedure Code Amendment Act 2002, Act 22 of 2002, Parliament inter alia inserted a proviso to Order 6, Rule 17 of the Code, which read as under, within inverted comma, provided that no application for amendment shall be allowed after the trial has commenced, unless the court comes to the conclusion that, in spite of due diligence, the party could not have raised the matter before the commencement of trial. Inverted comma closed. It is concluded. It is caused in a mandatory form. The court's jurisdiction to allow such an application is taken away unless the conditions precedent, therefore, are satisfied. Phase, it must come to a conclusion that, in spite of due diligence, the parties could not have raised the matter before the commencement of the trial. Para 11. From the order passed by the learned trial court, it is evident that the respondent had not been able to fulfill the said precondition. Full stop. The question therefore, which arises for consideration is as to whether the trial had commenced or not. Full stop. In our opinion, it did. Full stop. The date on which the issues are framed in the date of first hearing. Full stop. Provision of the Code of Civil Procedure envisages taking of various steps at different stages of the proceeding. Full stop. Filing of an affidavit in lieu of examination in chief of the witness, in our opinion, would amount to commencement of the proceeding. Full stop. Therefore, Honorable Supreme Court in paragraph number 19 has held as under. It is the primary duty of the court to decide as to whether such an amendment is necessary to decide the real dispute between the parties. Full stop. Only if such a condition is fulfilled, the amendment is to be allowed. Full stop. However, proviso appended to Order 6, Rule 17 of the Code restrict the power of the court. Full stop. It put an embargo on exercise of its jurisdiction. Full stop. The court's jurisdiction in a case of this nature is limited. Full stop. Thus, unless the jurisdictional fact as envisaged therein is found to be existing, the court will have no jurisdiction at all to allow the amendment of the claim. The aforesaid proposition is subsequently affirmed by Honorable Supreme Court in the case of Pandit Malhari Mahale versus Monica Pandit Mahale and others, reported in 2020 11 SCC, page number 549. 514. Third, in the instant case, going through the impugned order dated 23rd/4/2026, this court finds that the learned trial court has blissfully ignored the proviso to Rule 6 of Order 17 CPC. It has not directed any discussion in respect of the said proviso. And further, we are remanding the matter to the learned trial court to examine the matter again. Said proviso. Accordingly, taking note of the submission of learned counsel for the petitioner, and also taking note of the proposition of law laid down by Honorable Supreme Court in the case of Vidyabhai and subsequently in Malahari, this court is of the view that the impugned order fails to withstand the legal scrutiny, and accordingly the same is then set aside and quashed. The matter stands remanded to the learned trial court to afford an opportunity of being heard to both the parties and thereafter to decide the application afresh, keeping in mind the proviso to Rule 6, Order 17 CPC.
Abhilash,
And aforementioned exercise has to be carried out within a period of 4 weeks from the date of receipt of certified copy of this order. The petitioner shall obtain a certified copy of this order and place the same before the learned trial court within a period of 1 week from today.
Item number 8,
None appears for the petitioner on call, lays the matter after a week. In the event of subsequent non-representation, a preparator will follow.
Item number 9.
May it please your lordship. Lordship, the petitioner is a defendant of a title suit, my lord. And the title suit was disposed of by passing the judgment dated 6/9/2025 and the decree dated 9/9/2025. So thereafter, my lord, I being the defendant, my lord, I preferred a review application on 20/02/2026. That lordship will find it.
On what ground you have preferred the review petition?
Grounds, my lord, I have. My lord, grounds, lordship will find at page number 13. That, my lord, for that, the section 26(1) of the Protection of Domestic Violence Act enables an aggrieved woman to seek relief under section 18 to 22 of the Act in any legal proceeding before a civil, family, or criminal court, irrespective of whether such proceeding was initiated before or after the commencement of the Act. So, my lord, as because in that proceeding, my lord, I have filed my counterclaim also, my lord. And I have also contended this plea also, my lord. So therefore, my lord, I have filed the review application on 20/02/2026. And my lord, when, my lord, I have filed that review petition, my lord, delay was caused, my lord, 87 delay was caused. So along with the review application, I have filed one section 5 limitation application, my lord, for condoning the delay of 87 days. I filed it on 20/02/2026. And on, my lord, 23/02/2026, my lord, may annexure 3, my lord, page 30. Both, my lord, my applications, petitions were rejected, my lord. By saying that, my lord, I am reading, my lord, page number 30, dated 23, lordship got it? 23/02/2026. Case record is put up today on receiving the petition bearing so and so filed by the petitioner under section 114, read with order 47, rule 1 of the CPC, praying before the court to review the judgment and decree dated so and so, passed in title suit number so and so. Let the same be registered as Miss J case number so and so. On going through the case record, it has been seen that parenthood of the case has already disposed of and the court is in functus officio to proceed with the case. And, my lord, similar order was passed, my lord, on my limitation application petition also, that your lordship will find at page 31 and excerpt. So, my lord, the court ought to have, my lord, issued a notice, my lord, on the section 5 limitation application to examine, my lord, whether there was any sufficient cause for taking up the
Okay,
review
okay.
petition.
Heard, Mr. M. Datta, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 23rd to 2026 passed by the learned civil judge, Junior Division number 1, Gulagat, in Mizze case number 5 of 2026 and in Mizze case number 6 of 2026, arising out of title suit number 12 of 2017. It is to be noted here that by impugned orders dated 23rd to 2026, the learned civil judge, Junior Division number 1, within bracket trial court hereinafter, has dismissed the review petition filed by the petitioner under section 114, read with order 47, rule 1 of the Code of Civil Procedure, and the accompanying application under section 5 of the Limitation Act 1963. On the ground that the court had become functus officio after disposal of the suit without adjudicating either application on its merit. learned counsel for the petitioner submits that the petitioner was the defendant in the title suit number 12 of 2017 instituted before the Court of Learned Civil Judge Junior Division number 1 Golaghat. The said suit was decreed. Right judgment and order dated
6/9/2025 and decree dated 9/9/2020.
6/9/2025 and decree dated 9/9/2025. Yes, 2025. And thereafter, the petitioner herein has filed an application being application number 479 of 2026 under section 114 read with order 47 rule 1 of the Code of Civil Procedure for review of the judgment and decree dated 6/9/2025 and 9/9/2025 in title suit number 12 of 2025. And since there was delay of how many days?
87 days. Madam.
50?
87.
87 days in preparing the review petition. The petitioner herein has also filed one petition number 478 of 2026 under section 5 of the Limitation Act, read with section 151 for condemnation of delay. And upon the said applications, the learned trial court has registered Ms. case number 5 of 2026 and Ms. case number 6 of 2026, and thereafter dismiss both the petition by orders dated 23rd to 2026 on the ground that the court become functus officio after disposal of the case. The learned counsel for the petitioner further submits that the review is provided under section 114. Read with order 47 rule 1 CPC. And it is a statutory right, but the learned trial court, without considering the said aspect and without hearing the matter on merit, has dismissed the same on the ground that the court becomes functus officio, as the matter has already been disposed of. And as such, the impugned order fails to withstand the legal scrutiny, and therefore he is contended to interfere with the same. Having heard the submission of learned counsel for the applicant, the counsel for the petitioner, this court has carefully gone through the petition and the documents placed on record and the impugned order dated 23rd to 2026, passed in Ms. case number 5 of 2026, and also the impugned order dated 23rd to 2026, passed in Ms. case number 6 of 2026. And this court finds substance in the submission of Mr. Dr. Learned Counsel for the petitioner. It is to be noted here that right to review is indeed a statutory right under the CPC. It is provided under section 114, read with order 47. Order 47. And the review mechanism offers an exception to the principle of functus officio, which essentially means that once a judgment is delivered, the matter is concluded and cannot be revisited. However, the review process allows court to rectify grave error and ensure that justice is achieved. While a party who is dissatisfied with his judgment may appeal to the higher court, the review allows for a re-examination of the case in the same court. And the said remedy is provided under specific condition and is not intended to provide an opportunity to relitigate the case. In the instant case, the learned trial court has failed to exercise the jurisdiction conferred by the statute, that is CPC, under section 114 and order 47 CPC. And in view of the aforesaid provision, the principle of functus officio, who is the learned trial court, has applied in dismissing the petition to the considered opinion of this court, fails to withstand the legal scrutiny, and the learned trial court has failed to exercise the jurisdiction under section 114 and order 47 CPC. And in that view of the matter, this court is inclined to interfere with the order dated 23rd to 2026 passed in Ms. case number 5 of 2026 and also the Ms. case number 6 of 2026. The matter is then remanded to the learned trial court with a direction to restore both the Ms. cases to file and thereafter to proceed fast to hear the application number 478 of 2026 filed under section 5 of the Limitation Act and to pass necessary order. And in the event of condemnation of delay, the learned trial court shall proceed to hear the petition number 479 of 2026 filed under order 114 read with order 47 rule 1 of the Code of Civil Procedure on merit. In terms of above this, CRP stands disposed of.
I'm deeply obliged.
Item number 10.
My lord. Investigation petition, my lord, against condonation of delay in substitution by the trial court, my lord. In this case, a delay of 14 years, 5 months. About 14 years, 5 months has been condoned, my lord, by the impugned order, my lord. And the reason of the condonation delay was that allegedly the petitioner did not have knowledge about the facts about the pendency of the case filed by his father against his brother. That is his only reason. So, my lord, you kindly see the impugned order, my lord. My lord. It is at now page number 96.
Necessary, you come to the point.
My lord,
The ground assigned in the application is that the petitioner was out of the state.
my lord. His ground is that he was out of state, but he also says that if out of state for his education purpose, then service purpose. But he himself said that he frequently used to visit his residence at Gauhati.
Mm,
He frequently used to visit his place at residence at Gauhati.
mm,
So, if a person is frequently visiting his residence, and if the elder brother has obtained a cell deed, can it be expected that he did not have knowledge? And my lord, he said that in his petition, he said that the brother, his elder brother, that is opposed party, who is the petitioner here, he has obtained the cell deed without knowledge of family members. But my lord, at the same time, mother has filed a partition suit. In a partition suit, the mother has clearly said that yes, my husband has sold this property at Dhiranpada to my elder brother, and we are residing in a joint family. So, by these things, can it be imagined by any state of emergence that he did not have knowledge of the suit, my lord? He is frequently visiting Gauhati. He himself admits, my lord, petition may be. He said they used to visit Gauhati, my lord. If he
No,
used,
Mr. Soma, you say, there are several decisions of Supreme Court on this point. Supreme Court has stated that in the case of setting aside of abatement, court has to take a lenient view.
that is, but
So it is not your case that there is no explanation for the delay. There is an explanation for the delay, and the trial court has accepted the same. And trial court has in exercising the discretion, it has accepted the explanation and condoned the delay.
my-
So sitting in revision, can this court substitute its own view with that of the
definitely, my
trial
lord,
court?
this honorable court definitely see whether that discussion has been properly exercised or not. This court,
Hmm.
honorable court can see, but
Hmm.
more so when the such a huge delay, my lord. In my lord, 1924 Supreme
You
Court,
see,
my lord.
Mr. Soma, there is a decision of Supreme Court on this point. You take down it.
But-
Ramnath Sao alias Ramnath Sao and others versus Govardhan Sao and others. Reported in 2002, 3SCC, page number 195.
SCC, page 195, my lord. 2002,
195.
2002, 3 SCC.
2002, 3SCC, page number 195.
Sao,
So,
Ramnath Sao, my lord.
yes. In this case, Supreme Court has stated that lenient view has to be taken by the court.
My lord, that is correct. So there are several decisions where Supreme Court said that lenient view, but my lord, delay is of 14 years, 5 months, where records has been disposed of, everything is well. And the my lord, in 2024 Supreme Court, my lord, 2000 Supreme Court, the Supreme Court said that no, you have to, when the delay is such a huge, there is such a huge delay, the court has to be very seriously matter to look seriously. That para 26, the length of delay is a relevant matter which the court must take into consideration while considering whether the delay should be condoned or not. From the tenor of approach of the appellant, it appears that they want to fix their own period of limitation for instituting proceeding for which law has prescribed a period of limitation. Once it is held that party has lost his right to have the matter considered on merit because of his own inaction for a long, it cannot be presumed for long deliberation delay. In such circumstances, the case he cannot hard to plead the substantial justice deserves to be put against him. Then the court said that court owes a duty to first ascertain the bona fides of the explanation offered by the party seeking condonation. So whether the trial court has considered bona fides,
Where
my
is
lord,
the Malafide?
my lord.
Where is the Malafide?
My lord, Malafide is there that he was sitting idle for so many years, my lord. And I have annexed a copy of his acknowledgement. He received 5 lakhs rupees, 5 lakhs, and said that I have no rights. I have left all my rights upon the suit land, Dhiranpara land. He will not claim any right on the Dhiranpara land. I have received this. So already before execution of sale deed, he has already left his all rights.
No, we are not on the merit of the
No,
matter.
not Malafites, my lord. Malafites, my lord. I am showing Malafites, my lord. For so many years, he is sitting idle. When now, with regard to other family matters, or there is some dispute arose between the parties, so he dragged this property also in this matter. That is the Malafites. He has dragged this property also. That's the Malafites. That your lordship may consider all. If your lordship all for the records, everything will be before this honorable court, and definitely this honorable court will satisfied whether there was bona fides in his application, my lord. There is no bona fides, my lord. That is why the court said that we are of the view the question of limitation is not merely a technical consideration. The rules of limitation are based on principles of sound public policy and principles of equity.
No. Whether that decision relates to setting aside abatement.
My lord, this is not certified, but my lord, I have one another.
No, that may be in the application under Section 5 of the Limitation Act.
My lord, Section 5, my lord. Regarding
we are in setting aside abatement.
No, my lord, setting aside abatement is also with Section 5, my lord. My lord, setting aside abatement, 14 years, 5 months abatement, that is also with Section 5, my lord. It cannot only come under Order 20 Rule 9, my lord. It is accompanied by application under Section 5, my lord.
No, yes, Section 5 application is also filed.
Yes, my lord, that is also because without Section 5,
therefore, the decision you have relied upon may not be applicable here.
My lord, another decision I would like to produce right now. I am not having. I can produce it.
Okay, better, let us adjourn the matter today.
Yes, my lord.
You examine the case law I have preferred.
Yes, my lord. That 2002 CSCC
TSCC, page number 195.
195.
Yes.
Sure.
Heard, Mr.
Sure, ma'am.
Sharma, learned counsel for the petitioner. List the matter on when? Friday?
Okay, my lord.
For further consideration.
Very good.
Question number 12.
Yes.
Lordship. So I am the petitioner of this petition under Article 227 and 226, seeking early disposal of my title suit, which is pending before the learned trial court of Civil Senior Division, Amingao. So already I have evidence has concluded, written arguments has submitted, and oral submission also concluded. Then after the case has been deferred to some prolonged date of 29/8/2026. It's a very long distance, long actually date. So already I have suffered 9 years.
Where is that order?
So page number 11, 12, and 13. Already 11, both the parties are present and argument has concluded. Due to the actually transfer of the predecessor judge, the case has been actually delayed or in some inordinate date.
No. In the petition, you have stated that the learned trial court has fixed the case in the month of August.
Yeah. That order
Where is that
also,
order?
in page number 17, my lord. And there is a earlier order, my lord, page number 10, 29/4/25. The predecessor judge actually kept the suit as a speedy trial, page number 10. Despite of this order, the date has been deferred to some prolonged date 29/8/2016.
heard Mr. Manovendra Lokar, petitioner in person. The petitioner herein is aggrieved by the order dated 29/8/2026 passed by the learned civil judge, senior division, Kamrup Amingao. Passed in title suit number 25 of 2017. It is to be, no, not 29. By the order dated 28/6/2026. It is to be noted here that by order dated 28/6/2026, the learned civil judge, senior division, Kamrup Amingao, which will make a trial court herein after, has fixed the matter on 29/8/2026 for further argument. The petitioner in person submits that he has instituted one title suit number 25 of 2017 before the learned civil judge, senior division, Kamrup Amingao, and in the said title suit, the respondent herein as defendant entered appearance and contested the same. And after trial, the learned trial court has fixed the matter on 30/4/2026 for judgment. But on account of transfer of the presiding officer, the judgment could not be pronounced, and thereafter the matter was adjourned till 16/5/2026. On 16/5/2026, the new presiding officer, where is that order? 16/5/2026.
16.5, this order is in page number. Page number 13, page number 14, my lord.
Page number 14. On 16/5/2026, the petitioner in person as plaintiff has filed one petition number 1585 of 2026 for pronouncement of the judgment, and the learned trial court has fixed the matter on 25th of May 2026 for argument. And on 25/5/2026, the petitioner in person has submitted his written argument, and thereafter the learned trial court has fixed the matter on 28/6/2026 for further argument. And on 28/6/2026, the learned trial court heard the argument partly and fixed the matter on 29/8/2026 for further argument. The petitioner in person is aggrieved for prolonged delay whereby grave prejudice is caused to him, affecting his life, liberty, and livelihood, and thereby infringe the right granted to him under Article 15 to put in brackets small b and Article 21 of the Constitution of India. And under such circumstances, he has contended to issue direction to the learned trial court to dispose of the title suit number 25 of 2017 in a time-bound manner. But having heard the submission of learned counsel for the learned petition, the petitioner in person, this court has carefully gone through the petition and the documents placed on record, and also perused the order dated 16/5/2026, 25/5/2026, and 28/6/2026. And it appears that by the order dated 28/6/2026, the learned trial court has fixed the matter on 29/8/2026. It appears that on 16/5/2025, the petitioner in person has filed the petition number 1585 of 2026 for pronouncement of the judgment. And then the learned trial court has fixed the matter on 25/5/2026, on which the petitioner in person has already filed a written argument. If the petitioner in person has already filed a written argument, then this court failed to comprehend as to why the matter has been fixed again on 29/8/2026 for further argument. In that view of the matter, this court is inclined to dispose of this petition by directing the learned trial court to prepone the next date and to dispose of the title suit number 25 of 2017 within a period of 4 weeks. 4 weeks from today. The petitioner shall obtain a certified copy of this order and place the same before the learned trial court within a period of 1 week from today.
Offline.
May I please, Lordship. This case, my lord, the petitioner, my lord, filed a claim petition before the, my lord, learned Motor Accident Claims Tribunal, my lord, number 2 at Kamrup Matter,
Mr. Ahmed.
my lord.
How many adjournments you have already availed?
My lord, already so many adjournment, my lord, earlier taken.
So
my lord.
many
Yes, my
adjournments.
lord, from my lord.
How many adjournments you are entitled to under the law?
My lord, only, as per my lord, 3, my lord.
3.
Yes, my lord.
And how
But-
many adjournments you have availed since 2022?
My lord, there is no communication, my lord. That's why, my lord, some problems were there, my lord. Of course, my lord, that is on fault on the part of the, my lord, claimant, my lord. But anyway, my lord, I have filed a petition, my lord, on last occasion by preparing the evidence also, my lord.
So how this impugn order is illegal or arbitrary?
My lord, that's a, on my lord, I have filed a petition, my lord, on last, my lord, for recalling the order, my lord. That's all. For that order, my lord. Because, my lord, as a beneficial legislation, my lord.
Beneficial
the
legislation. Under
Tribunal-
beneficial legislation, you can avail as many
The
as
principles of, my lord, social justice, my
As-
lord, that's why. my
As
lord.
many as
Yes.
3 years,
Yes, my lord.
3 years or 4 years?
My lord, 3 years, my lord. Case was filed in my lord 2020, my lord, and thereafter, my lord, due to COVID situation, my lord, on 22, my lord, we could not, there was no any communication, my lord. Anyway, my lord, just at this stage, my lord, just the evidence was already prepared, my lord. Evidence is ready, my lord. By preparing the evidence, my lord, I have filed the, my lord, recalling
Then,
order, my
how
lord.
many witnesses you have examined so far?
But I have no exact, my lord, that's how many dates, my lord,
Hmm.
but from 2022, my lord. 22, my lord, and thereafter, my lord, on so many occasions, my lord. At this stage, my lord, already, my lord, evidence, after preparing the evidence, my lord, we have filed.
No, your preparation of
Yes.
evidence is not a ground for interfering with the impugn order.
My lord, now, my lord,
You have to justify.
my lord, evidence is ready, my lord, you lost it, my lord.
Hmm?
Just an opportunity may kindly be given, my lord, to file the same, my lord, already prepared. my
Sufficient opportunities afforded to you.
lord. Yes, my lord, it is.
Then? Hmm?
Someone release a victim, my lord, there's a accident, motor accident victim, my lord, is
Mhm.
suffering, my lord. There's a multiple fracture injuries, my lord, he has sustained, my lord.
Hmm?
Otherwise, my lord.
No, whether any witness has been examined.
No, my lord, no.
Not a single witness has been examined.
No, my lord, just a claim. This is the PW1, my lord. For filing the evidence of the PW1, my lord.
Mhm.
We are ready, my lord, at this stage, my lord, we have to file the evidence, my lord. Okay, on any date, my lord. Lawsuits may.
No,
It's the
on
time period.
30th/3/2026, you have been given the last opportunity.
Yes, my lord. And on that day also, my lord, we have filed a petition, my lord. Some documents, my lord, could not available, my lord, as a charge sheet, my lord.
Hmm?
My lord, a copy of, my lord, charge sheet and seizure list, other documents, my lord. Therefore, in trial court, my lord, those documents could not be obtained, my lord, due to some misplace of records, my lord. In 2020's record, my lord, that's why. Otherwise, my lord, medical papers are available, my lord. They will submit the same.
Are you sure that not a single witness has been examined on your
I am
behalf?
sure, my lord. I am sure. I am sure.
Heard Mr. Ahmed, learned counsel for the petitioner. This petition under section 115 of the CPC, read with Article 227 of the Constitution of India, is directed against the order dated 13/5/2026 passed by the learned member, Motor Accident Claim Tribunal number 2, Kamrup M. Gauhati, in MSC case number 1219 of 2020. It is to be noted here that by the impugn order dated 13/5/2026, the learned tribunal has dismissed the petition number 2916 dated 13/5/2026 under section 151 of the Code of Civil Procedure and section 169 of the MB Act for recalling the order dated 30th/3/2026 and allowing the claimant to adduce evidence. Mr. Ahmed, learned counsel for the petitioner submits that the petitioner has instituted a claim petition upon which MSC case number 1219 of 2020 has been registered by the learned tribunal. And issued notice to the opposite parties. And the opposite parties entered appearance and filed their written statement. And thereafter, the learned tribunal has fixed the matter for evidence. Sometime in the year 2020. No. No, on 5/4/2022. 2022. And since then, the petitioner herein could not adduce evidence due to want of certain documents, such as a search sheet,
Caesar list.
Caesar list. And also, there was COVID-19 pandemic in the year 2022. And thereafter, on 30/3/2026, the petitioner herein filed a petition number 2022 dated 30/3/2026 for adjournment of the case and to fix another date for evidence. And by the order dated 30/3/2026, the learned tribunal has given the last opportunity to produce the to adduce the evidence. But on that day also, the petitioner could not adduce evidence and file an application on application number 2022 dated 30/3/2026. And the same was dismissed by the learned tribunal on the ground that the petitioner has been taking adjournment since 5/4/2022, showing one cause or other. And in spite of getting several opportunities, they failed to file their evidence. Mr. Ahmed, learned counsel for the petitioner, further submits that the petitioner has already prepared his evidence in affidavit, and he may be granted one chance to adduce his evidence. And since the Motor Vehicle Act is a beneficial legislation, the petitioner herein may be given a chance to adduce evidence to establish his claim petition. Otherwise, serious prejudice will be caused to him. Having heard the submission of Mr. Ahmed, learned counsel for the petitioner, this court has carefully gone to the petition and the documents placed on record, and also perused the order dated 30/3/2026, and also the order dated 13/5/2026. It appears that the learned tribunal has afforded sufficient opportunity since 5/4/2022 to adduce evidence to the petitioner hearing. Though the grounds assigned by the petitioner is found to be not at all satisfactory yet, considering the fact that the petitioner will suffer prejudice in the event of denying him an opportunity to adduce evidence to in support of his claim petition. And accordingly, the learned tribunal, accordingly, this court is inclined to dispose of by directing the learned tribunal to afford an opportunity to the petitioner to adduce his evidence and to facilitate the petitioner to adduce his evidence, the impugned order dated 30/3/2026 and the order dated 13/5/2026 is then set aside in cost. The petitioner herein is directed to file his evidence in affidavit within a period of 1 week from today. And on such affidavit being filed, the learned tribunal shall accept the same and proceed to hear the matter in accordance with law.
Much obliged, lordships. Obliged, my lord.
Question number 14.
Lordship, the petitioners are the plaintiffs of a partition suit, and during the pendency of the suit, the defendant number 1 died, your lordship. And thereafter, 3 petitions were filed for substitution of the legal heirs, setting aside abatement, and for condonation of delay. By the impugned order, the delay was not condoned, your lordship. Though in the petition, the delay was mentioned as 106 days, your lordship, but as per calculation, it will be 19 days, your lordship. And the impugned order is at page 67. Para number 7 is the,
Delay was how many days?
in the petition, it was mentioned as 106 days, your lordship. But if we take the calculation, 150 days is the time, your lordship. It was calculated from 90 days, actually, in the petition. There was an inadvertent delay. Actually, it will be 19 days, your lordship. I have explained it in para 7 of my petition. In impugned order, page 68, your lordship, para number 7 is the relevant portion. The reason for rejection, your lordship. Page 68. Now, after hearing the version of both sides and going through the case record, it can be seen that the plaintiffs have stated the main reason for delay in filing the substitution petition was on account of the failure of the plaintiffs to meet their engaged counsel and for the failure of the plaintiffs to inform their engaged counsel about the death of defendant number 1. Now, the perusal of the case record goes to show that the defendant side on 21/11/22 by petition number so-and-so had informed the trial court about the death of the defendant number 1 so-and-so. And the plaintiff on the same day by petition number so prayed before the learned trial court for time to take steps for substitution of legal heirs of the deceased defendant number 1. The plaintiffs thereafter repeatedly took time for substitution of the legal heirs of deceased defendant number 1, and only on 4/4/23, the plaintiffs filed the petition, aforesaid petition so-and-so, 3 petitions, your lordship. So it glaringly shows that the plea taken by the plaintiff that they could not file the substitution petition as the plaintiff failed to meet them and to inform about the death of the defendant number 1 is a false and vague, as the defendant had already informed about the death of defendant number 1 before the trial court on so-and-so, and the plaintiffs too got full knowledge about the death of the defendant number 1. As such, on getting the information about the death of defendant number 1 has taken time to take steps for substitution. So the plaintiffs were all along aware about the death of the defendant number 1 were not ignorant about his death as asserted. The plaintiffs, in fact, despite of getting ample opportunity, failed to take steps for substitution of the defendant number 1. Lordship, in my petition, it is not a ground that I am not aware, Your Lordship. The petition is at page 48 and except 3. The delay petition. At para 4, I have explained the delay. This suit was initially pending before Munshif North Salmara, Your Lordship, at Abhayapuri. After the death, it was transferred to the Civil Judge Senior Division, Bongaigaon, Your Lordship. Page 48, Annexure 3. The court has said in the order that I was all along aware about the death of the defendant. That is not my ground. Para 4, if Lordship peruses, the instant suit was in the court of Munshif North Salmara, Abhayapuri on transfer for change in pecuniary jurisdiction for the suit. The same has again been transferred to the court of this honorable court after modification of the pecuniary jurisdiction of the suit. And the plaintiffs failed to meet their engaged advocate to inform him about the death of the defendant number 1 for taking steps for substitution of his legal heirs of the deceased defendant number 1 in his place in the suit. As a result, there has been such delay in filing the petition for substitution of legal heirs and of the deceased defendant number 1. So here the plaintiffs were aware about the death, but they could not meet the advocate at Bongaigaon, Your Lordship. This suit was transferred from Abhayapuri to Bongaigaon in the meantime. And regarding the actual delay, Your Lordship, in page number 8 of the petition of my petition, para 7 of the CRP, I have mentioned that page 8. I mentioned, though it is mentioned as 106 days, Your Lordship, actually it was filed on 169th day from the date of death.
When it was filed?
It was filed on 4/4/2023. And he passed away on 17/10/2022.
So this limitation period to set aside abatement has to be counted from whose date?
151 day, Your Lordship, 151 day. Recently, Your Lordship, I don't have a hard copy. Om Prakash Gupta versus Satish Chandra, 2025 INSC 183, Your Lordship. Supreme Court has explained it.
Where is that decision?
Lordship, 2025 INSC page, Lordship, I'll serve a hard copy, Your Lordship. I have no
When?
hard copy. Today itself, Your Lordship. If it is taken after 15 minutes, Your Lordship, I'll just
Okay, we'll
after the
take it up
motion
at 2 o'clock then.
at 2 o'clock.
What is the?
Number 15.
May it please your lordship. So I have come against the impugned order dated 5 March 2026, whereby my application under order 17, order 18, rule 17, read with section 151 was dismissed for re-examination of the plaintiff witness 1. Lordship, the impugned order is at page number 17, your lordship. Your lordship, if I may apprise the brief facts of the case, your lordship.
Page number 17.
Page number 17, your lordship, annexure A. Your lordship,
So where is your application under order 18, rule 17,
application is at page number 43.
43?
43.
Where you have mentioned the ground for recalling the witness?
Recalling paragraph 3, that on account of the fact that the surviving defendants are residents of places outside the local limits of the court, they could not keep regular contact with their earlier engaged counsel, which resulted in a communication gap. And as the earlier counsel for the defendants was not properly briefed by the defendants, certain pertinent questions arising out of the counterclaim of the defendant, which ought to have been put to the plaintiff witness 1, and which have a definite bearing on the outcome of the instant suit, could not be put to PW.
Is it a justified ground for recalling the witness?
Your Lordship, if I may apprise what had happened, Your Lordship, on paper, it's not
Hmm?
very accurately what has happened, Your Lordship. What has happened is the defendant, Your Lordship, I'm a subsequent defendant who have implemented myself in the suit. So I was subsequently.
Maybe you have filed your written statement
I
and
have filed a
counterclaim.
written statement and defendant number 3 to 8. So Your Lordship, now what has happened, I'm the present applicant is defendant number 4, 5, and 6.
Hmm.
Defendant number 3, 7, and 8, who are actually the main person conducting the suit, they in the meanwhile had expired, and they have not been implemented also subsequently by the plaintiff. So
Hmm.
there was a communication gap, and there was some loophole on my part also, Your Lordship, because not properly instructing the counsel. And subsequently, when I
No, you see, this power to record
yes, Your Lordship.
one witness already examined has to be exercised very rarely, in rare circumstances.
Your Lordship, the witness, the defendant number 3 to 8 have not examined the PW1. Your Lordship, another ground is that, Your Lordship, I have a counterclaim, and if those questions which was part of the, then my counterclaim will not remain only. And the plaintiff,
Maybe you have to establish your claim in the counterclaim by adducing your evidence.
yes, Your Lordship.
On that count, you cannot write for recalling the witness already examined.
Your Lordship, the witness was examined by the defendant number 1 and 2,
Hmm.
but I have never examined the witness. If a last chance can be given, Your Lordship, not.
No, 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 no.
Yep.
There are several decisions of Honorable Supreme Court.
Your Lordship, if you please-
When this power to recall the witnesses has to be exercised.
Your Lordship, if I may please, a judgment of the Supreme Court, Your Lordship.
Hmm. You cannot be allowed to fill up the lacuna.
Your Lordship, if I am.
Hmm. And
subject to
I
correct-
don't think this decision will help you.
Your Lordship, more than filling up the lacuna, Your Lordship, the present status is that I have not examined him only. So now what remains is that if I don't get an opportunity of at least examining him once, and I had in fact put up the questions also along with my petition before the learned trial court on what questions I would like to examine the PW1. So I had furnished a set of interrogatories also. Because Your Lordship, my right title interest is directly in contention because a part of the suit land, I am in occupation of the part of the suit land, which was inherited by me.
Maybe we are not on merit of the title suit or the counterclaim. We are on the merit of the application.
In Your Lordship, another aspect is that even since the cross of the PW1 was closed in the year 2022, Your Lordship,
Hmm.
but even the cross of defendant witness 1 is still continuing, Your Lordship, even still till today. So if I have given an opportunity, last chance may be given. Worship, I'll need only one day to
Mhm.
cross-examine him.
Let notice go at this is this. Heard, Mr.
G.R. Datta.
Learned counsel for the petition. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 5/3/2026 filed by passed by the learned civil judge, Junior Division Number 2, Kasar Silsar. It is to be noted here that by the impugn order dated so and so, the learned trial court has dismissed the petition filed by the petitioner under Order 18, Rule 17, read with Section 151 CPC for re-examination of PW1. PW1. Peruse the petition and the documents placed on record and also peruse the impugn order dated 5/3/2026. Let notice be issued to the respondents returnable in forwards that be taken by speed post and also by usual process within a week from today. List of forwards.
Deeply of you.
For orders, item number 24.
How the proposal was submitted?
Madam, that is, parents, madam, in the proposal, madam, date of installation was not mentioned, madam.
That has not been mentioned.
That is why, madam, their director has to resubmit the proposal, madam, indicating the date of installation.
Madam, see, this matter is pending since the year 2023.
Madam, otherwise, madam, SIV approval has already been given, madam, the next line, madam. This has been communicated as per the view of the finance SIV department wide endorsement, it is so and so. So, madam, may this matter may come immediately after 10 days, madam, 2 weeks, madam, in the.
After 10 days.
Madam.
Heard Mr. Islam, learned counsel for the petitioner, and also heard Ms. Sophia, learned standing counsel for the learned counsel for the respondents, the contender. Ms. Sophia has produced one letter dated 10/7/2026, written by the Deputy Secretary to the Gauhati Assam Department of School Education to the Director of Elementary Education, Assam, Kailipara.
July master plan.
Asking for resubmitting the proposal by indicating the effective date from which provincialization is sought for and the exact date from which the creation of the post is required immediately. And she further submits that she may be granted 10 days time to apprise this court about the up-to-date status of the creation of the post and the compliance of the order of this court. They are allowed, this is a list the matter on
Last week of July, madam.
27th.
29, madam, 29.
Okay, 29. This is a list the matter on 29. The letter produced before the court today shall be marked as Annexer D and be tagged with record.
Obliged.
Number 25.
Hmm. You are for the respondent.
Some of the respondent and some of them has already died during the pendency. But since 2018, this matter has never come up, so I could not hand over. I don't know even who is appearing for the appellants.
No, it might have been reflected in the cause list.
Yes, their name has been reflected. Submitted.
No, the counsel for the respondent or the appellant. Yes. None appears for the appellant on call. However, Mr. Dhor, learned counsel for the respondent number 1A, 1B, 1C,
One,
1D, and 3, 4,
one
5,
D,
and 7
has expired.
present. Mr. Dhor submits that respondent number 1,
One D, 3 and 5.
1D, and respondent number 3 and 5 already suffered demise. However, in absence of the learned counsel for the appellant, no effective order could be passed today, and accordingly the matter stands adjourned to be listed after a week, and in the event of subsequent non-representation of the appellant, appropriate order shall follow.
Obliged.
Item number 26.
May please. Lordship, this matter was earlier heard, Lordship, only the one issue was left, Lordship, to whether the applicability of the Lordship notification, which was two conditions were there, Lordship, whether the application, whether the rules that were prepared at the time of date of the diseases will be applicable, or Lordship, it was the subsequent rules will be applicable at the time of consideration. So basically, Lordship, to want a case that on last occasion my learned friend referred to, that this matter has been referred to lesser bench of the apex court. So that has not yet been disposed of. But Lordship, citing the judgment of that court, Lordship, similarly, Lordship, in 5th of 2025, one another judgment was passed by the apex court, Lordship, giving the details explanation regarding that issue, Lordship, which notification will be applicable. So I have the judgment, Lordship. Basically, this judgment also.
But who is appearing?
Yes,
for the
other side is not. The part that matter, Lordship, fixed on the Thursday,
Thursday.
Lordship. It will take little time, Lordship, for hearing.
Whose name is reflected in the cause list?
Mr. Borthakur, I Borthakur also.
Okay. Heard Mr. Kolita, learned counsel for the petitioner, none appears for the respondent on call. Lays the matter on Thursday
As a part that, Lordship.
as parted.
Lordship.
28.
Obliged.
May I please, your lordship?
Hmm.
My lord, there was a title put in between the plaintiff and defendant. It was decided on 25/4/2024, my lord. But as against that, my lord, I preferred an appeal, but with a 170 days delay. And that Miss case was registered as Miss J case number 159/2024, my lord. Now, my lord, when the service of notice was sent to those persons who were to appear in Miss J case number 159, my lord, then a report came on 24/12/2024, my lord, that defendant number 3, respondent number 3, respondent number 12 and 13 have expired. Now, my lord, as they expired during the pendency of the litigation, my lord, it was the bounden duty of the part of the plaintiff petitioner to implead them at party. That was not done. Now the learned, the first appellate court has shifted the burden on me, and for that purpose only, I would like to take your lordship to the order dated 37/2025 at page number 49, my lord.
Lordship.
If the before filing into the date of the so can be placed on the reports for admission hearing on this matter.
Admission hearing.
Admission hearing, because lordship or the sticky instructions from the file, there is the objection, so the decree has been already executed. So it is requested on lordship for admission hearing.
No, whether a decree can be passed against a dead person. Whether a decree can be passed against a dead person.
Lordship. I'm not getting.
Is it
My
not a
lord.
nullity?
My lord, at page number 50, at page number 50,
Anyway, Mr. Sutter,
yes, my lord,
today the matter is listed under the column order.
orders, yes, my lord.
If a service is completed, then we will list the matter for admission hearing. Heard Mr. Sutter, learned counsel for the petitioner, and Mr. Bakir, learned counsel for the respondent. It is submitted at the bar that the matter may be listed for admission hearing. Accordingly, it is provided that registrar shall list the matter on.
My lord, two matters are there before your lordship on 15. If your lordship is kind enough to fix on 15 or
15.
15 or 23, my lord.
When? 15?
50 copies are having.
Then 23rd.
23rd.
23rd on.
20, oblige me.
29 and 30.
Lordship, here I have received some instructions today again, Your Lordship.
Where is your counsel?
Lordship, he is in another court, Lordship.
Another court.
P. B. Purkaiste.
Yes.
I'm P. Bhattacharya appearing on behalf of P. Purkaiste, Lordship.
So, is he ready today to argue the matter?
Lordship, can it be on the next date, Your Lordship?
Next date?
Yes, next date, Your Lordship, because this is the instructions I have received today, Your Lordship. Today morning, while I was here, Your Lordship.
Okay. Heard Mr. Bhattacharya.
P. Bhattacharya.
Learned counsel appearing on behalf of Mr. B. Purkaiste. Learned counsel for the petitioner, and Ms. Terangpe, learned standing counsel for the education department. Ms. Terangpe has produced one letter dated 17 to 2025 of the Director of Secondary Education, addressed to the Standing Council, Gauhati High Court. And she submits that the matter may be listed on another date. Where allowed, list the matter on when?
Any date, my lord, is first week of August.
First week of August.
Subject to your lordship.
Where allowed, list the matter. 3rd of August. The letter produced before the court today shall be marked as annexure F, and we take the record.
May I please, Lord? My lord, in this case, my lord, as per official, my lord, 3/7/26, my lord, service is complete, my lord. So, my lord, matter will be listed for admission hearing, my lord.
Hearing, admission hearing.
Admission hearing.
Okay. Heard, Mr.
K.U. Ahmed.
K.U. Ahmed, learned counsel for the petitioner, and Mr. Ahmed, learned counsel for the respondent. It is submitted at the bar that service in this matter has been completed and it may be listed for admission hearing.
On 31st, my
Hereby,
lord.
this is a list the matter for admission hearing
On 31st, my lord.
after
31st of July.
5th of August.
15th.
5th. Pass.
43,
My lord, it may be 6, my lord, my lord.
6. Okay, 6.
May I please, your lordship, kindly this matter be taken up at 2 p.m. lordship.
Okay, sir. Okay.
May I submit, Lordship? Lordship, first of all, the order challenge is premature because the matter is fixed for hearing on the point of jurisdiction. Secondly, Lordship, the issue is already pending before this court, whether commercial court jurisdiction has been conferred upon the civil judge or not. That matter is fixed on 3rd of August for hearing. So matter is already subject. So this matter may also be taken out along with that matter.
Lordship, kindly take it up at 2. Lordship, Mr. KL will apply, he will apply the call, lordship.
Okay, at 2 o'clock.
Lordship. Much obliged.
34,
My lord, this is an application for condonation of delay of 33 days in filing the connected revision petition.
Heard, Mr. Paul, learned counsel for the applicant. This application under section 5 of the Limitation Act 1963 is preferred by the applicant for condonation of delay of 33 days in filing connected civil revision petition. Arising out of impugned judgment and order dated 6/12/2025 and the decree. Judgment and decree dated 6/12/2025, passed in title appeal number 12 of 2019 by the learned civil judge, senior division, Kamrup, Amingaon. Let notice be issued to the respondent opposite party returnable in 4 weeks that be taken by speed post and also by usual process within a week from today. List the matter after 4 weeks.
Published.
35,
May I please, lordship? I for condonation of delay of 6 years, 9 months, 15 days, total 2,473 days, my lord.
4,000 or 2,000?
My lord. 2,473
Okay.
days.
Heard, Mr. Islam, learned counsel for the applicant.
My lord, from the date of 11th September 2019.
Okay, this application under section 5 of the Limitation Act 1963 is prepared by the applicant for condonation of delay of 6 years, 9 months, 15 days, within bracket 2,473 days, in preferring regular second appeal under section 100 of the Code of Civil Procedure. Let notice be issued to the respondent opposite party returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. List after 4 weeks.
Deep law.
supplementary section number 37,
May I please,
Mhm.
Lordship? My lord, my lord, an order, my lord, which has been passed. My lord, may be pleased to find the order is at page, my lord, 15 of my IA. Lord,
This I is for
My lord, basically we're praying for restoration of the second appeal, my lord. Because, my lord, my instruction is that, my lord, due to some inadvertent communication mistakes, my lord, the appeal came to be closed on withdrawal, my lord. So admittedly, my lord, the appeal was not admitted. And then before that, this happens, my lord. This is the issue, my lord. So therefore, my lord, we are praying.
Is there any bar in withdrawing the appeal?
No. Oh, there is no bar, my lord. If now some my client instruct me, my lord, sometimes they do verbally and sometimes they do it by written, my lord.
Mm.
My lord, generally nowadays, therefore, my lord, I usually file an IA seeking withdrawal, my lord. These are the very awkward situation we have to face, my lord. So
Mm.
therefore, my lord, the instruction which they have, my lord, issued the present appellant is that, my lord, this appeal came to be closed on withdrawal, my lord. The instruction they do not have, my lord. We have made some specific paragraph in this IA also, my lord. So, my lord, the now as the appeal has not been, my lord, admitted or decided, so, my lord, can it be restored, my lord, and the, my lord, heard on merit, my lord?
Mr. Bhuya, you
Mal-
say you
mal.
cannot approve it or reprove it at the same time.
Sometimes, my lord, sometimes, my lord. Because, my lord, I even in my, my lord, tenure also, my lord, sometime I have made a prayer that the petitioner do not like to press or, my lord, they like to withdraw. Now, but, my lord, here is in this instant case, my lord, I have repeatedly asked, my lord, what was exactly happened, my lord. They says that the appeal should be, my lord, proceeded. But now this, now sometime, my lord, and the, my lord, I don't name the counsel also, my lord. He is also one of the respected senior counsel, my lord, who appears on that day, my lord. So something may have happened, my lord. And we have, my lord, made a research, my lord, that under such circumstances, my lord, what the Honorable Apex Court says, my lord, regarding the withdrawal without any authorization or instruction, my lord. Now, this is a case, my lord, wherein the without any authorization, my lord, or the instruction. Authorization, my lord, my submission, my lord, my respectful submission before my lord is that authorization by a written form is not there, my lord, was not there. Now, my lord, here is a case wherein, my lord, the appellant has come up before my lordships with an interlocutory application with sworn in by of an affidavit also, my lord.
No, Mr.
My
Bhuya,
lord.
is it not necessary to issue notice to the other side?
My lord, because the when this appeal was, my lord, withdrawn, my lord, there was no admission has not been done. Not even in the notice was not issued in the main appeal also, my lord. It is just, my lord, presenting an appeal for the first time before my lord, my lord, that the before issuance of the notice it came to be closed, my lord. That's the issue. Now, because, my lord,
No,
if the
maybe you see, there was an appeal,
yes, my lord, yes, second appeal, my lord,
second appeal.
my lord,
With the disposal of the first appeal,
my lord.
a right has been created in
Yes,
favor of the
that
other
is
side.
there. That is that I am not, my lord. My lord, bow down with my lordship's opinion, my lord. But only thing is that, my lord, as in the second appeal, my lord, when we come with a fresh appeal, my lord, by substantial question of law, my lord, sometime we can we satisfy my lordships or sometime we cannot, my lord. So if we cannot, then the appeal get dismissed without the, my lord, issuance of notice also. Now here is a case, my lord, that situation could not come because, my lord, the appeal when it was moved, before the, my lord, issue has been decided that whether the notice, that second appeal deserved notice to be not. Before that, my lord, it came to be withdrawn and closed, my lord. That's
Maybe
my
even
lord.
then there was
My lord,
a
only if my lord issue notice, my lord, then my another prayer, my lord, that the execution proceeding is pending in the, my lord, trial court below, my lord. That proceeding is some, if execution is done during this tenure, my lord, then the entire futile exercise.
no,
will be,
no,
my lord.
Mr. Bhuya, you see, without admitting the appeal,
My lord.
can we issue such order?
My lord, under the, my lord, I have a very limited knowledge on CPC, my lord. I have to run through, but one provision we have seen, my lord. CPC connection. My lord, that line, my lord, I have to satisfy, my lord, then it can be fixed on Wednesday, coming Wednesday, because, my lord, on 16th, they are coming with police and something, my lord, to grab the property, my lord.
Hmm.
It is a, my lord, dispute between the family, my lord. The property which is there, my lord, has already been partitioned by sitting the family members. Now they are disputing, my lord, that
No,
the,
let us
my
know one thing.
my lord,
Today we will issue notice to
My
the
lord.
other side.
my lord,
We will grant you liberty to serve the notice by Daslimut.
opposite
Oh.
parties, my lord.
You get it served
My lord,
and file an affidavit. We'll list the matter on next week,
my lord.
next Monday or Wednesday.
My lord, then this execution proceeding, my lord, some
No.
status quo or something like
No.
that, my lord.
The appeal is not before this court.
Then, my lord, I will produce this order before the execution court also, my lord, today's order, my lord. And
Yes,
they
you
may
can,
consider in accordance with law, my lord. The executing court, my lord. Today's notice order, if my lordship is pleased to go in.
Heard Mr. Ayer Bhuya, learned counsel for the applicant. This interlocutory application is preferred by the applicant for restoration of RSA number 185 of
My lord.
2024, which was withdrawn by the appellant hearing. By order dated
My lord, the white order dated, my lord, 24/02/2025.
in view of the order dated 24
24/02/2025, my lord.
24/02/2025. Where is that order?
Is at page 15, my lord. Is at page 15 of my part of annexure 1, my lord.
Let notice be issued to the opposite party,
My lord.
returnable on
Only one, my lord.
22nd of July. 22nd of July. Step be taken by speed post and also by usual process within 2 working days from today. Additionally, dust-day service is also permitted after effecting service upon the opposite party. The applicant hearing shall file an affidavit. List on Wednesday. You keep this judgment with you. You can produce
Yes,
it
yes,
on
ma'am.
that day.
My lord.
For admission at number
Obliged,
15.
deeply obliged.
May I please, Raj? In this case, they're supposed to file objection, but that objection not yet filed. And if they don't have any objection, the matter may be listed for hearing.
No, it is for amendment of the claim. And it was.
Amendment of
Amendment of claim.
And it was allowed. Against that order they have come. Record possibly not required.
amendment of
Plaint.
plaint.
And the plaintiff we filed a petition for amendment of the plaint and that was allowed. Against that matter, the defendant has referred this revision petition.
Okay.
But for that one, record possibly not required.
No, I'm not asking about record, listed for hearing.
Because they are enjoying the minority stay order. So if they have to take any problem, a date may be in the next week matter in admission column because it goes to the hearing column, then it is very difficult to, because my proceeding has been taken and the plaintiff.
Okay. Heard Mr. Ahmed, learned counsel for the Ahmed or Rahman?
Care Oman,
K. Rahman, learned counsel for the petitioner, and Mr. Hawk for the respondent. After hearing both the parties, it is provided that SSL lists the matter for admission on
Malad maybe come up after 15 of August, Malad. In these,
15 of
we have
first week.
First week of August.
Malad.
No, I don't know. I don't know.
Picked up.
5th of August.
Lot. Obliged. Interim is there, Malad.
Interim order passed earlier shall continue.
Obliged.
Supplementary section number 36.
Find out. Case is listed for final hearing today on merits, according to previous order.
So you are ready to argue the matter today?
I am also ready.
Come prepared at 2 p.m. then.
At 2 p.m.
Party aside. Party aside.
Matter number 19.
May I pray, my lord, the matter may be taken next Monday, my lord.
Why?
I have to prepare, my lord, because next Monday, my lord.
So this matter was listed on several occasions.
No, there is for condonation of delay. Now, in the admission, this is the first time, my lord, the matter has.
Today.
Yes, my lord. First time this.
Okay. Heard Mr. B. Sinha, learned counsel for the appellant. Mr. Sinha, price for listing the matter on
Next Monday, my lord. 27.
28th. 27 or 28th?
20th, 20.
20.
Obliged.
Fair along, resist and list the matter on.
Matter number 21.
Lordship, may kindly pass over the matter for time being, Lordship. My senior right now is in another court.
22.
May I please the lordship, my lord? Here I am the imperial defendant, my lord. Substantiation, your lordship will find page 5 of my memo. Though concurrent finding, my lord, against me, but there are, my lord, the judgment itself shows, my lord, that there are some only on the basis of preponderance of probabilities it is given. Although can be given, my lord, in the civil suit.
No,
my lord.
no. In civil cases, the
Yes, sir,
standard of proof is always
probability is
preponderance
always-
of probability.
It is so vague, but they find out, come to the conclusion that itself that the statement regarding the position and all these things are not sure, my lord. Though they file suit for declaration of right and interest and recovery of half position, although the partition part, my lord, in the joint property, there one line is there, but no discussion in the judgment, my lord, in any of the judgment, my lord. It's apparent, my lord. It is required to be have decided by your lordship, my lord. Substance question can be, my lord. At least two substance question is very relevant, my lord. Page number 5 of my memo of appeal, my lord. 1 and 2 can be clubbed together, my lord. And rest, my lord, regarding proving my lord, sale deed, whether has been proved in joint property, because we did not claim, counterclaim, my lord, did not make counterclaim, but it is his duty to say, we are saying that he does not have any land on this seller, my lord. How this sale deed can be? Those chain connecting sale deed were not there, my lord. And the perversity, my lord, the last one.
So you have suggested as many as 5 substantial question of law.
Yes,
Out of these 5, you are pressing upon only 1 and 2.
1 and 2, and my lord, this 3. Whether he has lawfully discharged, my lord. This will do, my lord.
No, the 3 may not be the substantial question of law.
Yes,
as
yes.
there is concurrent finding of
Yes. Then 5 is their perversity, my lord, because that is important. This will come to all, my lord.
No, perversity you have to demonstrate
Yes,
how it is perverse.
the perversity regarding the finding, my lord, even 1, 2 can cover, my lord, at the time of final hearing, my lord.
Hmm?
1, 2 can cover, my lord. There is apparently no finding, my lord. 1, 2, my lord, regarding partition. Although 1 line is there in the prayer. How, my lord, this joint property is to be, my lord.
Can be. There is a decision of Supreme Court.
Yes.
And also in Transfer of Property Act, there is a provision. স্কুটিনৰ আগতে এম দত্ত আৰু এটা জাজমেণ্ট আছে। Judgment is set on.
Here, my lord, it is among the family members, my lord, among the brothers' property and
No, হেৰিটো আনাৰ লগত। No, এম দত্ত আছিল। এই ক্ৰেডিটটো নাম। Judgment is set on.
here our cousins sold, my lord, without partition to the decree holder, the plaintiff, my lord.
Even or disposal. Nothing in it. Mahmoud আসলে আর বলবো আসলে। Mahmoud for the appellant আছিল। Okay, you come at 2 p.m. today.
My all right.
Please, Your Lordship. In item number 27, in order column, the item has been adjourned without taking our consent. There is some urgency in this matter. Kindly, can it be lifted up day after tomorrow? In item number 27.
It is difficult to believe you people.
They have to
Better you do one thing, you mention the matter tomorrow or any other date.
kindly change the date.
No, today they have already taken the date. We cannot change without informing them. You mention the matter.
They have not taken our consent.
Maybe. Maybe. The counsel for the applicant has submitted before the court that they have obtained consent. How can we ascertain it? Whether they have taken it or not?
I am for the respondent, so
That's all right. You mention the matter day after tomorrow.
Continue.
Yeah, 44, my lord.
Section 44 of transfer of
Yes,
property.
yes. This will cover my case.
Yes.
See, here, man, in this case, man, your lordship will find in the prayer there is one line for perfect partition. But in the judgment, my lord, both child court and appeal court judgment, no error is whisper, even in the final order. I can show this one page judgment, my lord, one page, the findings. No whisper regarding this part. This is important, I think. Just a relevant portion. I'll show this will suffice, I think. My lord, page 59, running page, the finding of the trial court. Then I'll show the appearance court also. my lord. This finding of the
59.
59, my lord.
Hmm.
Order, my lord. The result the suit decree with cost of the following relief. Decree passed declaring right to the interest of the plaintiff of Schedule A land. Decree passed for recovery of half percent Schedule C land, and to put the plaintiff in possession of the suit land by evicting the principal defendant and his man agent from the suit land, removing construction of the defendant over the suit land, decree permanent injunction, and so on, and entire cost of the suit. This is the only thing, my lord. Where is the whisper? But they themselves saying, my lord, that it is a practically joint property. That is why they have claimed for perfect partition, my lord. The plain one line is there in the prayer, perfect partition, but nothing has been given regarding perfect partition, my lord. They did not challenge it also for
No,
modification.
whether you have raised such an issue before the first appellate court?
Yes, my lord, my lord, first amendment, everywhere, our point is this, my lord. They have also admitted, my lord, because that is why their prayer is there, my lord, for perfect partition. Our claim is this, my lord. These are all ancestral property. This ancestral property originally, my lord. And the person who sold one
that's
of
all
our
right.
matter, he had no share. He has sold his
Though
share.
the ancestral property was not partitioned between the parties,
Yes.
yet the
We said there is a family partition, we said, but that has been rejected by the court. Because we could not prove, my lord. These aspects, this is a legal aspect, in fact. Because this is the decree, this is the judgment has been given, my lord. Where is the partition, my lord? It's a legal provision, my lord. Can you see, my lord? I will read just for 44, my lord. This section 44, slowly, my lord. Transferred by one co-owner, where one or two or more co-owner immovable property legally competent. That is their matter. On behalf of the transferee share such property to any interest therein. The transferee acquires such share or interest so far as necessary to give effect to the transfer right, point of position, and common part of enjoyment. That will be joint only. And to enforce partition of the same, but subject to the condition that liability affecting at the date of transfer the share or interest so transferred. Where transferee of a share of a dwelling house belong to an undivided family or is not a member of the family, nothing in this section shall deem to entitle him to the joint possession or other common part of the enjoyment of the house. This is also against them, my lord. This is also probably your lordship will be interested to look into it, my lord. Because had it been not a joint property, they would not have prayed for perfect partition, my lord. One line is there in the plain, my lord. So only these aspects also probably would be necessary in this case, my lord.
No, you see, as per
Other things are
section
there, my lord.
44, co-owner of the joint property can dispose of his part of the property.
But
So in
now
admin of the matter, the substantial question of law 1 and 2, as
Yes.
suggested by you, may not involve in this matter.
Subsequent question is whether the suit claiming on the basis of sale deed in respect of a joint property without claiming partition is sustainable. Now they claim partition, my lord, but that has been not reflected in the judgment, my lord. This is the case, judgment, no partition has been given, my lord. How he will get his right, my lord? Because he is the stranger who filed the suit, my lord. He said he has purchased it. That is the case, my lord. This will come with some modification, my lord. This substantial question, probably. Because he is a stranger. This perfectly suits in this section 44, my lord. He himself admitting in the plain, my lord, claiming for perfect partition. But no perfect partition has been granted, my lord. how the judgment is sustainable, my lord. In his favor, my lord, regarding recovery and declaration of right to the interest. This is a legal aspect, my lord. I can show, my lord, there played, my lord, only one line, my lord. Page 15, my lord. Last, page 15. C, my lord. D. This type to be of the plate, my lord. Type. Page 15, last one, my lord. D. A precept issued directing revenue of the knockout to grant perfect partition, my lord.
Page 50.
15, 15, sir. 15. Last one. That means it's a joint property, my lord. Family property, joint family property. They should have come for appeal, my lord. They did not. Now, how on the basis of this joint property execution will take place? It is a substantial question to be decided by them. Because we are claiming all along since the title should matter.
Okay, we will examine the issue.
Man.
Heard, Mr.
Yes,
Sururi, learned counsel for the appellant. Order reserved.
My lord, in the event of deciding, my lord, positive, my lord, then IA is there. It is up to your lordship, my lord.
Okay, we'll say. We'll say.
Obliged.
Standing item for motion, item number 14.
Lordship, I am relying on two judgments, Your Lordship, regarding that calculation, mode of calculation. Om Prakash Gupta, 2025 to SCR 937. Relevant para is para 11, Your Lordship. At page number, it starts from page 950. It says that the actual time,
Page number 11.
para 11, Your Lordship.
Para 11, yes.
Page 950. Rule 1, Order 22 CPC provides that when a party to the suit passes away, the suit will not abate if the right to sue survives. In instances where the right to sue does survive, the procedure for bringing on record the legal representative of the plaintiff appellant and the defendant respondent are provided in Rule 3 and Rule 4 respectively of the Order 22. The suit appeal automatically abates when an application to substitute the legal representative of the deceased party is not filed within a prescribed limitation period of 90 days from the date of death, as stipulated by Article 120 of Limitation Act. It could well be so that the death of a defendant respondent is not made known to the plaintiff or appellant within 90 days, being the period of limitation. Does it mean that the suit or appeal will not abate? The answer in view of the scheme of Order 22 cannot be in negative. In that view of scheme, in the event of the plaintiff appellant derives knowledge of death immediately after the suit appeal has abated, the remedy is available to file an application seeking setting aside abatement. The limitation wherefore is stipulated in Article 121, which allows the period of 60 days. Therefore, between 91st and 150th day after the death, one has to file an application for setting aside abatement. On the 151st day, this remedy becomes time-barred. Consequently, any application seeking to set aside the abatement must then be accompanied by a request contained in an application for condonation of delay under Section 5 of the Limitation Act in filing the application for setting aside abatement. Thus, the total time frame for filing an application for substitution and for setting aside abatement, as outlined in Article 120 and 121 of the Limitation Act, is 150 days. The question of condonation of delay through an application under Section 5 of the Limitation Act arises only after this period and not on the 91st day when the appeal or suit abates. From our limited experience on the bench of this court, we have found it somewhat of a frequent occurrence that after abatement of the suit and after the 150th day of the death, an application is filed for condonation of delay. This is what has happened in our case also, Your Lordship. Is filed after calculation is done after 90 days, Your Lordship. So in the petition, inadvertently, it is mentioned as 107 days. Whereas,
So you file corrected petition then?
Lordship, that with that observation, your Lordship, and also I'm relying on your Lordship knows, Lordship, that Ramnath Sahu case, your Lordship. Because it's a delay condonation petition for setting aside abatement, your Lordship. Ramnath Sahu case that says that it has to be construed in a liberal manner, your Lordship, because it gives a bigger effect to the parties, rights of the parties. If the suit abates against one of the parties, and it may have a bigger effect, your Lordship. With these two observation, I may be permitted to file a fresh application there, your Lordship,
Where?
before the trial court,
Okay.
by pointing out the correct delay and also with this observation. In para 7 of my petition, I have explained the delay, your Lordship. Actually, it is 19 days only. At page 8 of my petition.
Heard. Mr. Mukherjee, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 3/11/2025 passed by the learned civil judge, Senior Division Bohaigaon, in title suit number 44 of 2018. It is to be noted here that void order dated 3/11, impugn order dated 3/11/2025, the learned trial court has rejected the petition filed by the petitioner for condonation of delay and consequently dismissed the substitution petition and also the petition for setting aside abatement. Setting aside abatement. The learned counsel for the petitioner submits that the petitioner as plaintiff has instituted title suit number 44 of 2018 before the Court of Learned Civil Judge, Senior Division, Bohaigaon. And during the pendency of the said suit, defendant number 1 suffered demise on 17/10/2022. Thereafter, the petitioner herein has filed 3 petitions. One for substitution, one for setting aside abatement, and another for condonation of delay on 4/4/2023 before the learned trial court. The respondent herein as defendant file objection against the said petitions. Thereafter, the learned trial court, by impugn order dated 3/11/2026, was pleased to reject the petition for condonation of delay and consequently dismiss the other 2 petitions also as not maintainable and time barred. And being aggrieved, the petitioner approached this court by filing the present petition. Mr. Mukherjee, referring to paragraph number 7 of the petition, submits that in the petition number 1 through 37, the delay was mentioned as 106 days. However, in fact, the delay was much less, and that the defendant number 1 suffered demise on 17/10/2022, and the petitions were filed on 4/4/2023 after 169 days from the date of death. And that the provision of Order 22 CPC and the Limitation Act 1963, a substitution application is required to be filed within a period of 90 days from the date of death. And if such an application is not filed within the said period, then the suit abate as against the deceased person. And the limitation period to set aside abatement is 60 days. Thus, after 150th date, the day of death, an application is required to be filed for condonation of delay in filing the application for setting aside abatement. And as such, in the instant case, inadvertently in the petition was filed seeking condonation of delay in filing substitution petition, wherein the actual delay in filing the petition for setting aside abatement was 19 days only. But no, in support of his said submission, he has referred to a decision of Honorable Supreme Court in the case of Om Prakash Gupta alias Lalowa, which in bracket now this is through LRS and others versus Satish Chandra, which in bracket now this is through LRS. Reported in 2025 to SCR page number 937. And he has also referred to a decision of Honorable Supreme Court in the case of Ramnath Sahu alias Ramnath Sahu and others versus Govardhan Sahu and others, reported in AIR 2022. No, 2002, Supreme Court, page number 1201 to contend that in a contend that a petition for setting aside abatement and condonation of delay has to be dealt with liberally. But having heard the submission of Mr. Mukherjee, learned counsel for the petitioner, this court has carefully gone to the petition and the documents placed on record and also produced the impugned order dated dated 3/11/2025. And it appears that the learned trial court has held that the delay of 106 days has not properly been explained. And thereafter dismiss the petition. Dismiss the petition. It also appears from the decision of Honorable Supreme Court in the case of Om Prakash Gupta alias Lalwala, which in bracket Supra, especially from paragraph number 11, that the total time frame for filing an application for substitution and for setting aside abatement, as outlined in Article 120 and 121 of the Limitation Act, is 150, which in bracket 90 plus 60 days. And the question of condonation of delay, though an application under Section 5 of the Limitation Act arises only after this period and not on the 91st day when the suit struck appeal abates. But it appears from the impugned order that the learned that this aspect assumed consideration of the learned trial court while passing the impugned order dated so and so. And it appears that, in fact, the delay in filing the substitution petition is only 19 days. And in that view of the matter, this court is inclined to dispose of this petition by directing the learned trial court to examine the matter in view of the decision of Honorable Supreme Court in the case of Om Prakash Gupta alias Lalwala, especially paragraph number 11, and also the decision of Honorable Supreme Court in the case of Ramnath Sahu alias Ramnath Sahu and others, within brackets Supra. And thereafter to pass a fresh order in respect of the condonation of delay petition under Section 5 of the Limitation Act, and to facilitate in carrying out such an exercise, the impugned order dated so and so is then set aside. Set aside. In terms of above this, CRP instance dispose of at this motion stage itself.
Much obliged.
When the next
Next date is on 14/7, tomorrow, Your Lordship.
tomorrow,
For necessary orders, it's fixed for necessary orders. We'll inform the court.
For orders, item number 33.
Please, Lords. In this case, initially we instituted a commercial suit before the learned civil judge number 1. Lordship knows that on the basis of a notification, that is page 269 and annexure 9. On the basis of the notification, we instituted the suit. And that initially, Lordship, we filed the infringement of trademark for the learned district judge. That the office returned the plaint and said that this court has no jurisdiction, you have to file before the appropriate civil court. Lordship, initially the suit was entertained. When the defendant appeared, they filed application. That suit is not maintainable in view of the notification has been known as held to be known as in the law by this honorable court division bench. So Lordship, we accordingly we prayed before the learned civil judge that since this court has no jurisdiction, so return the plaint so for filing before the appropriate court. The learned trial court, Lordship, without sitting our prayer, to fix the case on 28/7 for further hearing on maintainability. But I come to hearing on maintainability, Lordship. Lordship, my prayer before Lordship, when the particular court has no jurisdiction, whether any law, any order has been passed, that is known as law, and be made specifically before the learned trial court.
no, if the trial court has fixed the matter on 28th July for hearing.
Lordship, may please to see.
7 July for hearing. It has not been adjudicated.
Lordship,
This is premature.
no,
No,
Lordship,
hearing on the point of maintainability.
Lordship, this honorable court has no jurisdiction, civil judge. Lordship, may please to see page 269. On the basis notification, we instituted the suit. And that notification has been satisfied by this honorable court, by division bench. Then initially when the court has no jurisdiction, whether court has entertained the suit, Lordship. And
No, that's why it has not admitted the matter. It has
no, Lordship,
fixed it for
injection was,
maintainability.
Lordship, what happened, Lordship, initially injection was granted. After full-fledged hearing, the injection was refused. And on that day, Lordship, the court has no jurisdiction, Lordship. And it was not known to us, Lordship. When the court is intimated us, immediately we prayed before the court that return the plaint. But in spite of that, Lordship, court has fixed the case for hearing on maintainability. Lordship, page 269, notification, Lordship, dated 13th of February 2019.
No, that's all right. You placed this notification along with the order of the division bench before the
Lordship, court
trial
knows,
court.
Lordship, court knows everything. But he has refused to return that if Lordship, in verbal discussion, court has said that
we cannot return because we have to return all the plaintiff before this renewal court file as a commercial suit. And this is admitted position. Let's say when the court has no jurisdiction, whether court can entertain, pass any order, lordship. And lordship, interestingly, the injunction trial court, after having known all the facts that court has no jurisdiction, they entertain the injunction petition on merit and pass the final order, lordship. Whether it is rejected or allowed, that is a different thing. But when my question before you, lordship, whether particular court has no jurisdiction, whether a court can pass any order, and lordship, it was not that the court was not known.
No, no. Now the matter is fixed for hearing on the point of maintainability.
Lordship, my question before your lordship, may please to see our prayer. We filed this application under 227. Lordship may come to page 11. And now, lordship, the problem with lordship here, page 11, paragraph 23 below. In view of the facts of the conduct stated above, it is not explicitly prayed that this honorable court may please to issue a direction to the learned trial court, Kamrup Civil Division number 1, to forthwith return the plaint in commercial suit number so and so to go with all the connected application, including injunction petition and under section 12 exemption application for presentation before the competent forum. Lordship, here interestingly, the suit was filed under the infringement of trademark act. When we presented we know under section 134, the suit lies before the district judge. And lordship, office of the learned district judge said that since it is a commercial suit, you have to present before the competent court, civil judge, lordship. Then we filed, lordship, in the meantime, many high courts has passed order that has went to Supreme Court. And Supreme Court in the meantime stated, since 134 says that the suit is live before the court, not inferior to the district judge, then it is live to the district judge, lordship. So in both the counts, even the lordship, the learned civil judge has no jurisdiction. And when the notification is, lordship, may please to see the judgment passed by this honorable court. Paragraph 12, lordship. Page 277. Lordship, for convenience, lordship, page 279, paragraph 14. Married lordship. Therefore, having said that the notification dated 13/12/2019, having been issued under the repeal ordinance, would have no effect. It would happen to the appropriate government to so and so. And lordship, paragraph 13, paragraph 12, paragraph 13, lordship, last 4 lines. Therefore, in further opinion of this court, the said notification dated so and so issued by the Judicial Department Assamese would not have any effect whatsoever, being non-extant law in the eye of law. Lordship, is the admitted fact that the court has no jurisdiction. Whether court can pass any order, lordship, any order passed by that court is non-extant law, lordship.
No, that's all right. Therefore, the court has fixed the matter for hearing on
Now,
the point
lordship,
of
court has entered into the merit of the case, and our injunction petition is rejected. We are hanging on the middle, lordship. We cannot even approach the
No, you wait till 28th.
No, lordship, I understand. When court has no jurisdiction, whether any order passed by the court has been any
No,
legal
court will
validity.
definitely take a call on this point.
No, lordship, the problem is with us, lordship, because the matter is relating to infringement of trademark again. Learned civil judge has entered into the merit of the case and rejected our injunction petition. And now, lordship, we cannot file appeal before against that order, lordship, because the order is non-extant law. Or lordship, provide that we can file appeal, lordship, then we can approach this court. For last more than two months, lordship, we are hanging in the middle, lordship. And it is admitted fact that that court has no jurisdiction. And the defendant, lordship, may please to see that WS. Their specific prayer is that the suit is not maintainable. Paragraph page 179, lordship, the written statement filed by the defendant. Paragraph 6. Page 180. Page 180, Lords. That this court has no inherent jurisdiction under the provision of the Commercial Act to try the suit on the following grounds. A, that the plaintiff clearly shows that the case of alleged violation of passing of due to use of long-standing trademark of the plaintiff by the defendant. As such, in violation of section 134 of the Trademark Act, as such, the court has no inherent jurisdiction to entertain the suit. Then let's see in next paragraph, they stated about setting aside that notification. So under the circumstances, let's see what will be decided by the London trial court. And moreover, let's see the London trial court has entered into the merit of the case. While
now the matter is pending for consideration of
one.
on the point of maintainability.
Lordship, when it is stated by the defendant that the court has no jurisdiction, we are conceding with their prayer that yes, this court has no jurisdiction to return our plaint for presenting before the appropriate court.
It's all right to wait for 28th.
Lordship, I understand, Lordship. For last 2 months, we are hanging in the air, Lordship.
No, for 1 week you,
Lordship,
one more week you wait.
No, suit was filed on 27th itself, Lordship. On 27th, court has been fixed the matter on reopening day. On that date, Lordship, the counsel for the defendant was not present before this court. And unnecessary, Lordship, client is suffering, Lordship. For the last more than 2 years, 2 months, Lordship. Lordship, please to see the injunction order. My question will.
No, you say in this petition you are challenging which order?
No, Lordship, we said that this court has no jurisdiction. And our prayer is clear. Prayer is very specific that the plaint should be returned to us when the court has no jurisdiction, Lordship. We are not challenging any order because injunction order, when the court has no inherent jurisdiction to entertain the suit, whether any order passed by that court is any legal validity. Lordship.
No. The question is, this revision petition is not against any order.
Yes, Lordship. Lordship, please to see our prayer and
how it is maintainable then?
it is maintainable because
How?
Lordship, because under 227, your Lordship has jurisdiction to superintend the jurisdiction of the lower court, Lordship. And when we have specifically made that the London civil judge has no jurisdiction to entertain the suit, this is our prayer, Lordship. I have read out my prayer also, page 11, Lordship.
No, that's all right. By which order the trial court has not considered your prayer?
No, Lordship, because Lordship 29 on 29? On 29/5, Lordship, the court has entered into the merit of the case.
No, that's all right. Where is that order?
Look, that is there.
And that order is not the subject matter of challenge in this petition.
Lordship, when the order is passed by the London trial court is known as in law.
First,
whether that can be challenged.
no, Mr. Kyle, now
Lordship.
you have to satisfy this court about the maintainability of this petition.
Yes,
under
Lordship,
Article
please to see.
227.
Lordship, please to see.
May I submit before my friend complete? Actually, I am appearing only for respondent number 2 and 3. And as regard respondent number 4, he is a dead person. We have already raised this issue before in our WS that number 4 is dead. Again, they have implicated them as a party. Although respondent number 4 is dead. And as regard respondent number 5, we have not represented number 5 before the Lord Court, and we are not representing number 5 before this honorable court.
Lordship, I saw from the documents that till date they have not filed any, their partnership deed shows that the person is alive. Under the circumstances, we are bound to implicate him as a party. It is their duty to submit before the court that the person is dead, and their partnership deed shows that the person is alive.
No. If he has taken such a plea in his written statement, then
What, Lordship?
he submitted that he has taken a plea in his written statement.
Yes, Lordship, he has taken the plea.
Then
And Lordship, on the face of the record, the Lordship, I have annexed the order passed by this honorable court division bench that this notification has been set
maybe
aside.
first they have satisfied this court about the
Yes,
maintainability
please
of
to
this
hear.
petition. We will list the matter on 21st of July.
Lordship, on Friday it may be listed. Lord.
Sorry. Heard Mr. Kyle, learned counsel for the petitioner, Mr. Khandelia for the respondent number
2 and 3.
Respondent number 2 and 3. list the matter on 21st of July for hearing on the point of maintainability.
Lordship.
As this petition is directed not against any impugned order. Madam, for respondent number 1. Caveat would be heard, caveat stands decides.
For admission, item number 36.
My lord, we the petitioners file this CRP IO seeking dismissal of title suit 97, 2025. Because the suit is filed under wrong provision of law.
Under?
Wrong provision of law. Right title interest of the person must be filed under section 34 of Specific Relief Act 1963 covered under declarative suit. Opposite party have filed right title interest of the person under section 39 CPC. Those are, so the suit is not maintainable in law. And secondly, title suit 97 violates order 23 rule 14 CPC. First, they have filed title suit 2319 seeking perpetual injunction and mandatory injunction. And after 6 years, they suddenly withdraw the suit without any court permission, without any liberty to they again file same subject matter, family settlement and injunction. For family settlement, is to be registered. Where is the registered deed? This is a false case. True owner is late Bokanto Kumar Talukdar. Late Bokanto Kumar Talukdar has transferred his self-acquired property to two daughters who registered will. Opposite party is a disowned son of late Bokanto Talukdar. He is not the owner of this land. We are paying municipality tax, revenue tax are in full possession. Opposite party is living in West Baragaon since many years. And our late father has built 1 foot wall and fence to protect our land from heavy water logging, from drain backside and front side and to trespass. Opposite party has in the year 2018 damaged this 1 foot wall so that rainwater came and damaged our house, and we have faced dengue, malaria. The present 1 foot wall and fence is in current location for 40 years back without any prior objection. Professional land survey confirms the wall that it is our boundary. So our request to this honorable court to dismiss this title suit, which is filed under wrong provision of law. How can lower court allow right title interest of a person to be filed under injunction section? And also title suit 97 violates order 23 rule 14 CPC. What order 23 rule 14 says that if a plaintiff withdraw this suit without any court permission, they are not allowed to file a fresh suit without court permission in same subject matter and same cause of action.
So earlier suit was withdrawn.
Yeah, without any court permission. They again refile.
No. Without court permission, how can the suit be withdrawn?
They have withdrawn without any reason. And again, seeking
Now
previous.
court has allowed it.
No, court has allowed, but the court has without permission to file a new suit with same cause of action.
No, the trial court has observed that the cause of action is completely different.
Completely, no, their trial court, civil judge 5 years erred in law. Because earlier the suit title suit 2319 has been filed in Civil Judge Junior Division 1. Lower court record page 10 reveals the truth that without court permission, without liberty, they have filed, withdraw the suit, and again, they have not taken any liberty to file a same cause of action. Lower court record page 10 reveal all the truth. They have not taken any liberty.
Where is that order? Withdrawal
Lower
order?
court record, lower court, civil judge, Junior Division Court number 1. 17/3/2025, the order.
So the suit was withdrawn on the ground of sense of pecuniary jurisdiction.
Yes, Lordship, exactly. We had earlier round of CRP.
This order is from Civil Judge
No,
Junior Division
you
1.
say this court has granted the liberty.
Yes, yes. Exactly.
No, my lord. The lower court, court number Civil Judge 1, they have specifically written without liberty that they have given the
No,
order.
this court has permitted by order dated 15/5/2024.
Without liberty, without liberty to file fresh suit.
No,
Our reply we have
you
left
come
on
to
this.
paragraph number 4.
Yes.
It is made clear that withdrawal of the instant petition or for that matter, the order dated 7/2/2024 passed in Ms. J case number
Yes, Lordship.
179 of 2020 in title suit number 23 of 2019 shall not preclude the petitioner
Yes.
to file a separate suit if otherwise permissible under the law.
No, my lord. This order is from Junior Division, not from High Court. Junior Division Court number 1.
No,
I have marked
he
that.
said,
I have the flag number also.
this court has permitted him to file a fresh suit
No, my lord, civil judge junior division 1 order I have tick mark also. Without liberty, they freshly written. Not high court order, not civil judge junior division court number 5 order, but 1 order. Court number
Where is
1.
that order?
Annex, I have annex there.
Page number? Annexer?
Lower court record, page 10. I have
No, in this petition. Annexer number?
I have written there this IA civil 688 page 38. I have given reply. Specifically written there. Without the petitioner has not taken any liberty. দেখাই দিব লাগিছিল।
Written submission. You show the document. Show the order.
Lower court record to লাগিছিল।
Next to the video.
21.
So it is an ancestral property. There is an ancestral property schedule LN. Schedule LN is 1 bigger 3 quarter 10 lessons. Out of 1 bigger 3 quarter 10 lessons, your lordship, only in respect of 2 quarters of land, suit has been filed. Claiming that it is our ancestral property. So the defendants, they have forcibly occupied our land, that is 2 quarters of land. So the defendant has taken a plea that your suit is barred by adverse person. Defendant's taken a plea in the written statement. Suit is barred because of adverse person. That means when adverse person has been taken, plea of adverse person has been taken, then the title of the true owner is admitted. Always adverse person lies against the true owner. Is a plea taken in the written statement. And another plea they have taken in the written statement that no, it is not your land. It is not the Pata land. Rather, it is a railway land. There's 2 pleas. One plea is for adverse person. Another plea is it is a land belongs to the railway. And as and when railway acts, we'll vacate it.
No. In the case of adverse possession, you have to admit the ownership of the other side.
Other side. That means I am the plaintiff. I filed the suit. Defendant claim that your suit is barred because of adverse person. That means I am the plaintiff. My suit is barred. Why? Because already 12 years has been gone. We are in possession of the more than 30 years, more than 12 years. So we have acquired the title by way of adverse person. That is their plea. Defendant's plea. When the defendant has taken the plea of adverse person, then my title has been admitted. My plaintiff's title has been admitted in a suit property. That is the law. Because adverse person always lies against the true owner. That one plea is that adverse person. Another plea they have taken the written statement that no, it is a railway land. We are occupying and possessing the land of railway. And as and when the railway will ask, I will vacate it. We will vacate. That is the plea taken by defendant number 1 to 12. We filed this suit against the defendant number 1 to 17. 1 to 12 taken the plea that the suit is barred under adverse possession. I am coming to the written statement.
Hmm.
Written statement of lordship at page 34, annexure 2. Page 35, paragraph number 14. Lordship got it. Page 35, it is second page of written statement, paragraph number 14.
Yes.
The suit is barred by principle of adverse possession.
Hmm.
That means my title has been admitted. I cannot evict you because I cannot evict the defendant because they have acquired the title of adverse possession. But so far the case is concerned, they have not made any counterclaim. A plea has been taken. Now I am coming to page number 37, para 22. Lordship got it. That the real state of affairs of the in the suit that the Panusek, the husband of the defendant number 1, the father of the defendant number 2, 3, 4, 5, and the father-in-law of the defendant number 7, 8, 9, and Idris Ali, the husband of the defendant number 10, the father of the defendant number 11, the father-in-law of the defendant number 12, both were brothers. That the 30 years ago, the predecessor in the interest of the answering defendant started to use the suit land of 2 kotha for residential purpose by constructing temporary houses and thereon along with defendant number so and so, as the suit land was a railway land. So, two plea they have taken. I am not on that. One is adverse possession, that is I am claiming that I am true owner. And another plea has taken the railway land. All right, they may take the plea. So they have to establish it is a railway land, but they have failed. They could not establish it, the railway land. Rather, it is a remains patta land. But it is title has been admitted. When railway land gone, the adverse person comes, true owner comes. So the learned trial court held, we have exhibited because it is our ancestral property. Our grandfather was the owner. We have exhibited the copy of Jamabandi since the year 1931, 30, 31, 37, 38, 57, 58, 68, 69.
Jamabandi or any other document?
I am coming to that. Because it is a grandfather's property, the ancestral property. We have not the other documents. So Jamabandi is we have exhibited the land revenue paying receipt, we have exhibited the
Jamabandi is not a title document.
No, definitely not. So for the ancestral property is concerned, what document will remain with us? Unless and until law is established, unless and until the revenue record is rebutted, then it is a document of title as per land revenue regulation. Our High Court judgment is there. Unless and until it is rebutted, it is to be rebutted. No, you are not the owner of the property. That revenue record is not correct because I am the owner of the property. My document is there. When this claim comes, then Jamamandi goes. If it is not rebutted, then it can be considered the document of title. Our High Court decision.
No, then why the trial court has not
The trial court says, because our father's name is Durga Datta Khetawat. Durga Datta's father was Dhanalal Khetawat. Trial court says a question has been asked in a cross-examination that you are not the son of Dhanalal Khetawat. The witness PW1 says, no, I am not the son of Dhanalal Khetawat because Dhanalal Khetawat is our grandfather. Dhanalal Khetawat's son is Durga Datta Khetawat and my father is Durga Datta. So question has been asked by the defendant side, are you son of Dhanalal Khetawat? No. The trial court says, you being not the son of Dhanalal Khetawat, we have exhibited the documents. There is clearly reveals that it is a Dhanlal Khetwat. Thereafter, it has been inherited by the Durgarat Khetwat. After the death of Durgarat Khetwat, we inherited it. We got their name mutated in the year 1980-89. Trial court says, Your Lordship, so he being not the son of Dhanlal Khetwat, you cannot. So that is a substantial question of law we have proposed. Because when they have admitted the title by claiming adverse possession, then what remains to be proved? I am the true owner. When I am the true owner, then the only relief claims against them that you have, whether you are in possession of the so and so, they are their owner. Whether you are able to prove it, if they can able to prove it that they are in possession of that property more than 12 years, then they are entitled. My suit will go. I am true owner. But the learned trial court, Lordship, in deciding the issue, only issue number 3 and 4 had been decided. Only 4 issues are there. 1 and 2 decided in my favor. 3 and 4. 3 and 4 regarding whether the plaintiff has right title and interest over the suit land, whether the plaintiff are entitled to decree as paid for. There are 2 issues decided against me. Holding that, Your Lordship, I am coming to page number 55. That is a judgment has been relied. 2007 6 SCC 186. It was held, Lordship got it. It was held that an entry in the revenue record does not confer title on a person. The entries in the revenue records have only physical purpose. Lordship, thereafter, another line is there in the judgment that it is the civil court is to decide the title. But that part left. How civil court will decide? Civil court decide on the basis of the pleadings, on the basis of the documents submitted. Now, the plaintiff side exhibited certified copies of Jamabandi, land revenue paying receipt, municipality tax paying receipts, which clearly do not confer title of ownership. All right. When the plaintiff defendant admits that you are my true owner and I acquired adverse possession, what remains to be proved? Nothing remains.
How the trial, first appellate court has dealt with this?
Taken them simply. Simply. And first appellate court, Lordship, I am just giving the last findings. Lordship, accordingly, I find that the learned trial court rightly decided the issue number 3 against the plaintiff.
What is the issue number 3?
Issue number 3, whether the plaintiff have right title and interest. I have the right title inherited property 1 bigger 2 quarter 10 lessons of 3 10 lessons of land, 1 bigger 3 quarter 10 lessons. Out of that 2 quarter is a land remaining in my possession still.
Now the land is in your possession.
Yes.
In your possession or in
No,
their
it is. So for 2 quarter is in their possession. So there is a suit for right title interest recovery of possession. Their claim is that adverse possession. So, Lordship, I substantial question of page number 1, most probably 1 and 3 will be 1 and 3, Lordship. Whether the revenue records, that is the Jamamandi exhibit 1 to 10 exhibited by the plaintiff in respect to suit land being not challenged, rebutted, can be presumed as a document of title as provided under section 41(2) of the Assam Land Revenue Regulation. It is our High Court judgment, Lordship, 2002.
Where is that judge?
Lordship is there. Copy, I have forgotten to bring it. Lordship, that is number pair 2002 3 GLR 1.
That's can you? Print out.
Well, you are coming with the mouth, you know.
No lines.
And recent decision, your lordship, Supreme Court decision is there.
Okay. Yes.
Recent decision 2023 INSC 1009 para 2012 on the basis of revenue record cannot be extinguished, cannot create a title. There is that cannot be extinguished.
That decision is with you now?
Yes, yes. No, today not available, lordship. I can.
Today not
supply.
available.
Lordship, sorry, lordship.
So let it be on a Wednesday then.
No problem.
Heard Mr. R.K. Munya, learned senior counsel, assisted by Mr. S.S. Singh, learned counsel for the appellant. Leaves the matter on Wednesday for further consideration.
Pending item number 36.
And also, my lord, case is filed under wrong provision of law.
Yes, Mr. Sharma,
Yes, lordship.
this is page number 89.
Yes.
The order of the trial court dated 17/3/2023.
Yes.
Without granting any liberty, you have been allowed to withdraw the suit.
Yes, lordship. On that point, I am submitting, lordship. To that effect, I have already submitted my affidavit in opposition. My plea may kindly be seen. Earlier page, 23/19. At page number 70. From page number 70 onwards, it is starting. And the last portion, cause of action portions. At page number 85 of my reply.
Without liberty is a subsequent order.
At page number 85, the cause of action. Here mentioned we have almost 10 numbers of cause of action of the earlier suit. It was filed way back in the year 2019 in the month of January. It was withdrawn by order is 17/3/25.
Last
In view
order
of the- in view of the
17/9/20.
Please don't disturb, let him complete.
In view of the liberty given by Honorable High Court, by its order dated 15/5/24. Honorable High Court's earlier CRP we kindly listen. Order is 15/5/24.
No, in that order,
Yes.
reference was there in respect of the order dated 7/2/2024.
Yes, Lordship.
But this order is dated 17/3/2025.
17/3, yes, Lordship. It is order is passed by the Learned Lordship Court, number
Hmm.
1 Gauhati.
17/3/2025.
Yes.
But you have preferred the civil revision petition
Yes.
against the order dated 7/2/2024.
Yes. That order was earlier rejected by the Learned Trial Court, Your Honor, because during pendency of suit, what happened? Our father, both parties' father expired on 3rd day of July 2019. That father, during the lifetime, he had given me the property in question by open verbal understanding on 10/7/2012.
No, these are these
And
own
that
son.
matter, so as to bring that matter on line, we had filed one amendment petition for the plaint. And that amendment petition was rejected by the Learned Trial Court. Against that, we had approached before the Honorable High Court. And Honorable High Court granted that liberty. If otherwise permissible, it can be filed. Accordingly, we had filed this suit, that is suit number 97, at page number 90, or page number 90, may kindly visit. Here, cause of action is completely different. We had prayed for rights that in the ideal suit, we had prayed for particular injunction against their nuisance. And in this suit, we had filed right title injunction on the basis of family settlement dated 10/7/2012. By which our late father had granted our property, honor, that is suit property. And accordingly, here if your lordship see
My
cause of
lord,
action para.
my lord, misleading court, same cause of action, perpetual injunction, mandatory, same title suit 97 and title suit 23.
Cause of action para may kindly see 101.
For family settlement,
After
it is to be registered. How can a
97 of
Madam,
Zone-
please sit down.
97 of 24. Page number 101, our cause of action para.
Yes.
Yes, 101. The cause of action of the suit, that is suit number, subsequent suit 97 of 25, arose on 3/7/19 when our father expired, with both parties' father, late Gauhati Kumar Talkar. On 29/8/20, when the plaintiff filed a miss case, that is 179 of 20, seeking amendment of the title suit 23 of 19, that was the earlier suit, so as to insert a prayer of right title interest. On 7/2/24, 15/5/24, these are all subsequent cause of action. 6/2/25 and 14/2/25. Series of cause of action, series of events took place between us on subsequent day after withdrawal of the suit. That's why we filed this suit, seeking right title interest in the disputed land, making them necessary party, and also mandatory injunction. In the meantime, what's happened, Your Honor? They have made barber fencing around our suit plot, Your Honor. We used to stay at the Gorsuk area, Your Honor. They used to say the Urubari area, Gauhati, Your Honor. That is our paternal property. What paternal property has given to us by our family partition, they had made a barber fencing. In the meantime, during pendency of this suit also, subsequent suit also, they have, what's happening, Your Honor? They have undertaken permanent construction, that is the boundary wall, thereby causing us disruption so that we cannot approach to our paternal property, that is the Sampavuti Kuti. It is named after our great grandfather, who she was the mother of our grandfather, Your Honor. There's a Sampavuti so that we cannot approach it. That's why we have filed another I seeking mandatory direction to them so that they cannot raise the boundary wall, thereby blocking our entrance, which is the only entrance so as to approach our maternal property, Your Honor, which is given by our late father. That is construction they have started on and from 18 to 2000.
They are not the
18 to
owners of this land.
2024. Accordingly, we have filed this IA, Your Honor, that is pending before your lordship. And they have filed their reply also. In their reply, they have admitted that they have raised boundary wall around this property, and that is they have admitted by giving certain photographs also. We have given these photographs.
To
also.
a
In this
we
photograph,
are not building this property.
Please sit down.
that is their property also, our property also. Until or unless the property is amicably settled upon in view of the command given by our late father, that is on 10/7/2012, Your Honor. In view of that command, Your Honor, we have filed this suit subsequently, Your Honor. That is the newly constructed boundary wall, and that is our house situated. That is Sampavuti Kuti in the name of my great grandmother, and that is their RCC building. We have two plots. One plot is 11 lessa, another plot is 1 kotha 3 lessa. In 1 kotha 3 lessa, our occupation is there, but it is often submerged during the time of rainy season by the water coming from the Sorania Hills, Your Honor.
That's why we temporarily shifted to the Gorsuk area, Your Honor. We have temporary tenanted occupation is there, no doubt, Your Honor. But so far, their permanent construction is there, the RCC building we have given to them because they are my own sisters, including herself also.
No,
she is
no,
also
no,
litigant,
my
Your
lord,
Honor, in the
he
present
is a
case.
division, sir.
I am the elder brother.
Daughter has transferred this property not to him, but to other daughters.
Later trial we continued lordship before that. There is nothing at all so far the vested jurisdiction is for.
Original
Learned trial
owner
has not given anything
Bill
which
this
is against their interest.
will prevent waterlogging.
If your lordship see the subsequent cause of action, this cause of action is completely different compared to the earlier cause of action, Your Honor. The earlier suit was filed when our father was alive. Subsequently, father expired, Your Honor, in the year 2019, in the month of July. Subsequently, we filed the amendment petition. Amendment petition was refused by the learned trial court, that is Munshi number 1 here in Gauhati. Subsequently, we filed the CRP. And in case of CRP, this Honorable High Court has given us a liberty. So, if otherwise permissible, we can file a separate suit, Your Honor. Provided the pecuniary jurisdiction also permitted, Your Honor. Provided. And then accordingly, the subsequently filed, and cause of action portion is completely different compared to the other. Accordingly, learned trial court giving this order, that is learned municipal file, that is a subsequent trial court. The order is very balanced order and very reason order, Lordship, 29/11/25. Both sides were represented. When the suit was withdrawn on 17/3/25, that time also they were present before the learned trial court.
No,
Even my client was also
we are
present.
not
It is
concerned
recorded-
about it.
it is
We are not,
recorded in the order itself, Your Honor.
we are not concerned about it.
29/11/25. That is their impugn order from their petition itself. That is page number 47. Page number 47. Both sides are represented. The petitioner defendant, that is them, submitted that the instant suit should be rejected under Order 7 Rule 11D. Order 7 Rule 11D provides if from the pleadings of the plaintiff appearance that suit is barred under any provision of law, then the learned trial court can act upon rejecting the plaintiff order. That is the provision of Order 7 Rule 11D of CPC. As the OP plaintiff without permission, without liberty, that is their plea before the learned trial, to file the fresh suit, that is suit number 97 of 25. This suit is between the same parties, not same parties. Parties are to some extent different. In the earlier case, one gentleman was there, some Kosik person was there, that is their relative. He caused disturbance at that time, 2019, and subsequently this Kosik is not there. And the same cause of action is also same like the previous suit. Cause of action is also cause of action is a series of events, series of facts presented by the parties. That the earlier suit as well as the present suit is on the same subject matter. That is the injunction and family settlement. That is their plea. Injunction and family settlement. The opposite party plaintiff who has submitted before the learned trial court under Order 7 Rule 11D is not at all maintainable. They have submitted the cause of action of both the suits is different. Parties are to some extent different, and the natures of the prayer. In the earlier suit, we had prayed for partial injunction so as to prevent their nuisances. They constantly give nuisances in our paternal property. And subsequent suit, we had prayed for after the death of our father, after granting permission by the Honorable High Court, right title interest on the basis of the family settlement dated 10/7/2012. Subsequently, they further submitted, they have filed a civil revision application. We have submitted before the learned trial court, before the Honorable High Court, CRP number 155/24, wherein Honorable High Court at a very initial stage granted leave in favor of the opposite party plaintiff to file separate suit if otherwise permissible under the law by his order dated 15/5/24. The opposite party plaintiff has bona fide lost the subsequent suit. We have bona fide lost the subsequent suit, seeking separate reliefs, that is right title interest on the basis of bona fide family settlement dated 10/7/12. Mandatory injunction we have filed because they have entirely property has been, they have circled, they have blocked, they have not allowed us to enter into from the date of 18 to 2025. Because they have raised completely new boundary walls. I have, accordingly on being compelled, I have filed one IA lordship in my entire photographs. There is A series photograph, that is 1688 lordship. 688 of the 26. Lordship has found probably 688 of the 26. In this year, we have filed. From the days of 18 February 2026, they have raised these boundary walls around the whole
Page
whole
number,
campus of our
page
house.
number,
688.
no, page number.
Page number lordship 10. Page number 10.
Yes.
Yes. These are the photographs. On the basis of Google photographs, we have the GPS also system was there. Timing is also mentioned. Paragraph 11, 10, 11. One mason is also working, undertaking boundary wall construction around our whole house, situated at Blueberry area near Kosturba Gandhi Ashram. And also paragraph number 12, page number 12. Probably Lordship has seen the mason is also undertaking work. New boundary wall construction, new bricks are seen, new construction. 14, paragraph 16 also, 8, 5, A series, 15, as well as the 16. In the meantime, we have filed one FIR on that same day, on 18 to 26. FIR may kindly be seen also, that is page number 70.
Thereafter, what happened? Injunction was granted.
Injunction was not granted. Well, I would like to submit all this also.
We have filed written.
Injunction is not yet granted, Lordship. They have undertaken already construction, wall is already almost half.
They are not the
Almost half
owner
the
of this land. They are not the owner of this land.
Almost 4 feet boundary wall has been undertaken against.
Owner is late Bokhato Talukdar. We have
No, madam, please sit down.
let me also to.
Yes, yes.
Page number 70, annexure, page number 17 of our I. To the officer in charge, control to the police station, Gauhati.
Okay, you have not been granted any mandatory injunction.
Yes, I have not been granted. I am just pursuing this matter. Lordship.
Okay.
They have submitted objection also in the 688. They have submitted, Lordship. I'd like to refer the FIR also.
Not necessary. Not
On the basis
necessary.
of this FIR, the police station has not done anything here because the matter is subject before the court. There is a municipal court, Gauhati, as well as the Honorable High Court. That's why they have approached us. They have called us that you should rather go to the courts.
So according to you, this impugn order suffers from no infirmity or
infirmity.
illegality.
It was passed as per vested jurisdiction by the Dane High Court below.
Okay.
No, my lord. How
Okay.
can a right title interest of a person to be filed under injunction?
Okay, your
section?
part is over. Okay, sit down.
How can a right title interest of a person to be filed under injunction section? Right title interest of a person to be filed under section 34 of the Specific Relief Act 1963 covered under declaratory suit. They are seeking right title interest falls under declaratory suit. Already one declaratory suit is there. Kamrup Metro 2 title suit 242. Two parallel suit is non-maintainable in law. And also opposite party is not the owner of this land. True owner is late Bokanta Kumar Talukdar. He had no relation with his opposite party. He's a dijon son, paper publication and dijon documents. True owner late Bokanta Kumar Talukdar self-acquired property transferred to two loyal daughters through registered will number 367 2018. True owner has built this 1 foot wall. We have given photograph in reply. 40 years back to prevent heavy water logging from drain inside, outside. We are facing heavy the malaria, dengue water coming from a drain to our house. And this present 1 foot wall and fence is in current location for 40 years back without any prior objection. Professional land survey confirms the one.
No, we will not go into merit of your merit of the title suit. We are concerned only with the impugn order. Here.
You impugn the whole order is wrong. How can a lower court allow right title interest of a person to be filed under injunction section? Lower court had
No, this CRP is not against that injunction order.
Whole order is wrong.
Hmm?
How can a lower court allow opposite party to file right title interest of a person to be filed under injunction section? And second is without.
No, we are not concerned with that injunction order. We are concerned with this order,
Dismiss-
interim order dated 29/11/2025.
Dismiss this subsequent title suit 97 because the suit is filed under wrong provision of law. And without liberty from court, they have filed the same cause of action. For family settlement is to be registered. Where is the registration deed? Totally false case.
Yeah, all facts taken plead before a learned trial court by a proper evidence, proper pleading. It can be addressed upon by learned
No,
trial
my lord, it cannot be title
These are all
subsequent. It cannot be allowed because whole title suit is filed under wrong section. It's not maintainable in law. Opposite time, a party cannot create new law. Right title interest must be filed under section 34, not section 39.
Okay. Heard, miss, your name, please?
H.M. Talukdar Roy Chaudhary.
Learned counsel for the petitioner and Mr. Sharma for the respondent are been concluded. Order is out.
First of we had one IA also, Lordship.
Is it necessary to hear the IA? We'll finally
It is
dispose
not
of this
necessary.
CRP.
It is not necessary because, yes, must have let out.
You have any other point? No,
What is the order? I have not heard.
we reserve the order.
Oh, why, my lord?
Pardon?
Why, my lord, case is filed under wrong section. And
We reserve the order. We will pass the order later on.
Oh, must oblige, must oblige.